It is, I am an MSME. I have taken loan and I have been asked to pay foreclosure charges on floating rate of interest. So, Lordship, if this matter could be heard,
So what is the urgency?
Lordship, I am an MSME. I need funds to operate my business.
So who will give the fund to you?
Lordship,
To run your business or offer your own fund?
already been taken by the bank for foreclosure charges, Lordship. And as per law, there cannot be.
Okay,
any
give the list. We'll see. Whatever give the mentioning list, mentioning the reason, I will see to that if this court finds that it is required.
Next second. This is the matter between the sugar industry and the juice industry.
What inclusion?
Even in the next month, my lord,
What inclusion? What is the inclusion?
for inclusion as a respondent to the petition, my lord, we have already heard this at length, my lord. I'm led by Mr. Bachawat, my lord. God may kindly really what next month, my lord.
Whatever the application, whatever the mentioning, give the mentioning the reason, I will see.
Next second.
I will not hear one by one for mentioning, only I will hear with regard to the unlisted. With regard to other mentioning,
2 days
with the mentioning list, I will.
My lord, 2 days back, I have mentioned this matter. Lord, she was appreciating the RTC director. My lord, to appear today as within 10 RTC matters. My lord, there was a specific direction. My matter is appearing at item number 64, my lord. Lordship's direction was it to appear within 10 urgent matters. No, I am paying leave and let it appear any day, my lord, within 10 matters.
Mentioningly give to my officer, I will.
So it has already been appreciated.
I will see it. I will see.
Lordship, I'm praying for this matter, Lordship, recommendation. Lordship, I have to mention a matter. Lordship, on the 11th of August, your Lordship was pleased to direct an order for the physical presence of the Principal Secretary, Judicial Department, Lordship. But your Lordship, yesterday at around 7, there was served, Lordship, where it was only mentioned that the matter to be appeared on 14th.
That matter come tomorrow, I will explain.
I'm praying for leave.
I'm for your court. I will listen tomorrow.
Yes.
Then
But for inclusion also.
you want a petition in the matter. Let the matter come.
Lordship, I'm praying for leave.
I want to face of the secretary. I will fix a specific day on Saturday or Sunday. The secretary will come and meet with you.
Lordship, I'm praying for this matter. Lordship,
The mention will not take any mentioning list. Give the mentioning list to my court officer. I will see in the evening. Listed social matter. What is unlisted?
recommendation notice has been issued, Lordship. Saying recommendation appointment letter has been issued, Lordship. 17 is a verification date, Lordship. In the meantime, they have issued a notification wherever name appearing in the sale list, and the recommendation has been cancelled, Lordship. 17 is a verification.
Lordship mentioned the matter. My lord, I am saying.
That's what the file has. That's one
Same issue, my lord, verification.
Yes, what is it?
So 5 days, my lord. I want urgent leave petition. Urgency is there. Total 7 petitioners of one family, my lord. Professor, doctor, engineer of government service, my lord. Your scheduled time certificate was cancelled by the SDO. On the ground of jurisdiction, I have come before your lordship. And lordship, I not only that SDO communicated that order to the university. I am a professor, 57 years old, my lord.
Why it has been what certificate?
Scheduled time certificate.
Scheduled type certificate. Whether a hearing was given to you?
SDO has no jurisdiction. Your lordship already passed on judgment, my lord. Steering committee is the jurisdiction, my lord. So for that reason, I have come before your lordship, my lord.
देखो Wednesday. Matters issue notice.
Mentioned this matter before my lord. You had mentioned this before my lord on 10th, my lord, on Tuesday. Not my tandem, not technical bit was rejected. Your lordship asked you to appear among the first 10 matters today. But it has not appeared in the list today, Lord. Lord, I
Similar like Mr. Sinha Milot, we had filed, like Mr. Sinha Milot, I had filed on 23rd July. Milot was supposed to come on 29th July. We have tried with the registry Milot, it's not appearing. Only Milot, let it appear. That's all, Milot.
I have an urgency, Lordship. Lordship petitioner.
Give the mentioning list. I will take all the matter, no problem.
May I just speak leave?
Yes, what is the leave?
I attend the conference at Netherlands, Amsterdam in Netherlands. Lordship, the meeting will be conference will be held 17 August 2026 and 21st August 2026. Lordship, kindly.
First August is over.
Lordship, leaves the matter.
First August is over.
Lordship, kindly leave the matter tomorrow. Lordship.
First August is over. So what relief court can give now?
Kindly leave the matter tomorrow.
Yes.
I'm sitting.
You amends decide who will mention the matter first. I will take the matter. I will not hear
Permission.
together.
Only with the Lordship's permission. I'm a NEET UG candidate, my lord. I'm a NEET UG aspirant. My counseling starts from today. I'm falling under the EWS category. I have applied for an EWS certificate. I was also previously issued the same. But this time my EWS certificate has not been issued on the grounds that my mother's name has been deleted from the SIR. Because I'm only requesting that the
So your name is in the this voter epic
voter
list.
list. Yes, ma'am.
Your name is available.
Yes.
So what do you want now?
Because I'm only requesting that my matter may be urgently heard so that the EWS.
It is not the SIR matter.
No, no, it's not an SIR matter. It's relating to NEET counseling. The counseling starts from today itself.
Monday within 5 minutes.
How much?
to file this read application regarding my lord the kidney transplantation of the
Kidney transplantation is nothing. Yes. The matter is pending kidney transplantation. Yes. You file it, then come.
I'm seeking leave to.
Yes, you have given the slip.
Yes, your lordship Milot wanted the slip after Mr. Sinha Milot will kindly see only for listing I am asking.
Okay, I will see.
Second slip.
You have given, I will.
May I have your lordship's kindly to mention, Lord?
There's an urgency in the matter. Matter was due to be listed yesterday. Day before yesterday, my senior had mentioned urgency was satisfied. My lords were pleased to direct that the matter will be listed between item 1 to 10. Motion. My lord it did not come up in the list tomorrow. That is the only urgency. Urgency was.
There is a slip.
My lord, the slip has been submitted.
Okay. Yes.
Write the slip, my lord. If my lord writes it, it will get listed. My lord, we mentioned it day before yesterday.
You have mentioned all the reasons.
Right, my
Okay,
lord.
I will see. Yes, Mr. Bhattacharya. Let the senior speak some.
Item 53.
Yes.
Item 53.
Yes.
Milord, this is the interim order is going to expire on 20th.
20?
28.
8. Okay.
20.
Okay.
Now, Milord, my lords has passed this order that this is that matter, tender matter where the other side was also appearing. Lordship wanted to dispose of so that I can complete the tender.
Okay. Interim order is under 20. Matter appeared 13. 13 not appeared. Let इसको 20 अगस्त है ना 20 अगस्त को 20 अगस्त क्या डेट है क्या दिन है
It is appeared item 53.
and let it be remain in the list if it got upward if it not come please mention on 19th then I will take it.
Lord, may I have your lordship's kindly to mention the matter, Lord, virtually?
Future handling balance loss.
Huh?
A 3-year-old child, future handling balance loss. That's why I'm mentioning this matter urgently. The father is a permanent resident of Canada and the child is a Canadian citizen, 3 years old, and the mother is Indian citizen. Mother came to India along with her child, and since then, from April 2026, the visa has expired. Since then, mother has not been renewed the visa, nor she go back to Canada to.
Have you informed to the authority?
Yes, we have.
Your visa was extended.
No.
Then
Visa has
when the visa was expired.
April 2026.
So you are not informed to the foreign officers?
We have sent our representation to FRO,
Ah.
and but FRO did not take any steps
Ah.
regarding that.
Ah.
Lordship,
So what do you want?
there is an apprehension that any kind of adverse proceeding can be.
Naturally, if the visa is expired and you are in the India without the visa, then naturally the action will be taken against you under the Foreigners Act.
Absolutely, your lord.
Then
That's why I'm mentioning this.
So why?
mentioning,
restraining for taking action?
No, your
Then
lordship. To compel the mother to take the child to Canada, or at least release the child to, if the authority or
who has kept the child?
the mother.
Mother has kept the child in
Mother is
Canada.
Indian citizen.
Indian, yes.
Indian citizen, he kept the child.
Ah.
Even after the visa has been expired.
Ah.
So that's my prayer, Lord.
So what is your prayer?
Prayer is inclusion in the list, if your lordship.
Inclusion, what is your prayer in the writ petition?
Lordship, visa for the child. That's
Visa
my
for
prayer.
the child.
That's my
Say that. उसको मत
On matter of petitioner after the School Service Commission, verification my lord, dated my lord 28th August. And in the meantime, my lord, circular issued, those whose name was deleted from the list, my lord, kindly.
Naturally.
They were deleted from the list that
So you have preferred an appeal before the appellate authority?
Yes, yes.
When you preferred an appeal?
Appeal, my lord, in the meantime, after the deletion, my lord, within 15 days.
Okay, you do one thing.
Permitted to mention this is for inclusion in the list.
Give an upgradation, give the mentioning list to my court officer on, I will only hear with regard to the unlisted motion. I will not hear.
Lord, may I have your lordship kindly to mention a matter, my lord, unlisted.
For what?
My lord, may I, my lord?
What is the urgency to leave?
My lord, the urgency is, my lord, there is a escrow account where the money has to come to me. The bank is not allowing that escrow to function, and parallelly they are going under IBC to go against me. Any day the section 7 is going to, any day next week your lordship will keep it. My lord, I'll just show one clause and it should probably satisfy.
Which matter?
Well, it's unlisted matter. My lord, my junior is there with the list.
Just handed over the. I have
My
another.
lord, may I be allowed?
No, it is
Any day.
it's already listed.
No, my lord, it's an unlisted matter. It's not in the list.
Unlisted. Where is the unlisted? Where is the writ petition?
It's.
Oh, you.
No, but it's
It can be unlisted.
Oh, I thought anything that's not in the list would be.
Madam.
Very well. We'll just give the slip and your lordship will consider it the slip then.
My lord, may I- My lord, I be allowed?
Last occasion, my lord.
One matter, my lord, for
Portal was mentioned this matter, and my lord, please to direct that to top fix this matter and top 10 today list matter. But the matter was listed on 50, item number 56 matter.
What can like this? If suppose 10 persons are mentioned top, so how it will counted? If every person 1, 2, 3, 10 cannot be taken as a.
Already 80% hearing is done, my lord.
Yes.
80% hearing was done, my lord. Kindly take the or any gentleman. In top.
You give the mentioning.
Matter is regarding the death of my mother, the journal of a land manager is not declaring the property of the records in the favor of the three sons. It's a simple matter for long. Item number 128.
Give. Yes, what you're telling? What is the urgency?
My lord, for the permission of Puja, my lord, the petition was that was not listed, so I am correction my year and I to press read to get permission for Puja, my lord.
That is the puja.
My lord. Yes, my lord. Today is any
18 is on Tuesday. Monday, okay. Monday within 5 minutes, issue notice to the author.
your lord, possible that your lordship,
5 minutes. Issue, tell them to issue notice. Give. What about the mentioning? Yes, call the list.
your lordship, your lordship,
Who is number? Dancing on us. Homicide certificate, my lord, kindly. Who is in item number 1?
Respondent number 3.
Who is appearing for the respondent number 7? Along with Mr. Banerjee, because both are argued together, subsequently are argued separately, but he has not given the name. What is his name?
Name is Mr. Morthal.
One person has appeared and argued the matter.
Understand, he was standing by.
And tomorrow I will pass an order. Tomorrow he will come. My name is not included in the list.
My lords, it is there, my lords. It is there in the order, my lords. It is.
You had appeared?
Yes, my lords, I had appeared. My lords.
What is the name?
My lords, Mr. Supriyo Ranjan Mahapatra, my lords.
Huh?
Mr. Supriyo Ranjan Mahapatra, my lords.
Yes. All the 3 applications have been allowed. All 3 applications allowed.
My lords, kindly fix the date, please, my lord, for the main matter, please, my lord. For the main writ petition, if your lordship will kindly fix the date, my lord.
First you complete the direction, that amendment and all these things, then you come.
We were just
Please.
My lord was in 38 and now the pressure of mentioning.
Yes. Who is item number 2? Item number 2.
Item number 2, my lord, I beg to appear for the.
My lord, I appear for the respondent number 5 ECL.
5 to 8. He's appearing virtually.
Mr. Thakkar,
My lord, kindly permit me to appear. My lord, kindly have page 23 once, please, my lord. Kindly have page 23
My lord,
once.
before my learned senior friend begins, my lord, may I make a submission?
led by Mr. Thakkar, my lord, he's logged in.
My lord, before my learned senior friend makes a submission, my lord, may I have a word, my lord? My lord, I appear for ECL. My lord, I am humbly seeking, my lord, 2 days time to seek instructions. My lord, they've challenged the tender process. My lord, I have sought instructions from them. My lord, kindly gives me 2 days time, keeps in on Monday, Tuesday, subject to the convenience of the court.
My lord, I'm not challenging anything. Just if I may just indicate, my lord, if your lordship sees 23, the tender was closed on 7th March 2026. It has to be finalized in 120 days, my lord, which expired on 6th of July. And the Coal India guidelines say you can finalize at page 70. If your lordship sees the Coal India guideline at page 130 says you have to finalize within 135 days. You cannot keep this pending forever. So, my lord, that also expired on 21st July. Now, there are obviously, my lord, forces at play because of which the company is not finalizing the tender. All that I'm seeking, my lord, is that they should finalize the tender this way or that way. Award it to anybody. I'm not challenging any tender condition, but I want compliance of the tender conditions, my lord.
Yes.
Which they are not doing.
My lord.
Yes, Mr. Agarwal, why you are not taking a proper decision for with regard to the issuance of the tender?
My lord, there is a notification of the DGMS, my lord, which is a subject matter of discussion in this matter. My lord, I have sought instructions from the ECL with respect to this DGMS. My lord, there was an earlier circular which said the certificate has to be provided by only 4 government institutions. My lord, then after issuance of the tender, my lord, a clarification has been brought by the DGMS, Directorate General of Mine Safety, saying other government bodies can also issue that certificate. My lord, since the tender was issued at a time when these other government bodies could not have certified this, my lord. Hence, my lord, a decision has been taken by the ECL to reconsider the tender process. And my lord, my learned senior friend is only a participant in the bid. My lord, there is no concluded contract. There is no letter of award.
He's on it like that. So he's telling that you conclude the contract either this way or that way. You cancel the tender, nor you awarded the work. The tender process in March it was over. So why you are not concluding the tender? Either this way, either reject or allow.
My lord, this is the specific instruction I sought from ECL, my lord. What is the process of the tender today?
What you are submitting, whether you can change your stand after the tender process is parties have participated in tender process, then you can take any further view.
That is why I said, my lord, external forces are at play here. That is why the company is not doing it.
Can you go behind the tender condition? Whatever the DGM say, the DGM cannot incorporate the further condition in the tender process, which has already been occurred and which the parties have participated. How you can change the game now?
My lord, kindly allow me 2 days time to take information as to what is the present situation of the tender. My lord, I shall come back on the email.
Plaintiff counsel appearing for the respondent number 2, prays for 2 days time to take instruction. Accordingly, for the interest of justice, case is adjourned. Let the matter appear.
My lord, with my learned senior's permission, my lord, I am instructed, my lord, let them at least for go.
My lord, let them file a report.
They have not taken
Let
decision.
fi- No, let them file a report, my lord. Come with a report because oral submission, my lord, may not.
Not to take any further steps and let the matter appear.
Then, my lord will kindly, my lord kindly allows me 2 days time. My lord kindly does not pass any order. My lord kindly allows me 2 days time. I shall come back on Monday itself.
See, Mr. Agarwal, you are taking time from this court. Taking time, this court is granting time, then in the meantime, you cannot pass any adverse order.
Very well.
Fixed on 18th of August. 1st of August within 10 minutes.
Mr. Agarwal was appearing for respondent number 5 to it.
He's telling 2.
No,
My lord,
5, item number.
Respondent number 5. Huh?
Published.
Yes, next.
Item number 3, I appear for the petition. Pursuant to lawsuit direction.
I appear for the Reserve Bank of India.
Officer
I appear, my lord, for HDFC Bank, my lord.
investigating officer has been made party, my lord, has served, my lord, his executive.
Notice served.
Copy served, my lord. The case, what the petitioner is, my lord,
Who is the investigating officer in agency?
the district of my lord, Vaishali district, Bihar.
Bihar. Yes.
This is a case, my lord, the petitioner is, my lord, carrying on business of, my lord, FL offshore. My lord, 7 customers every day come and, my lord, purchase the, my lord, liquor. My lord, the petitioner, my lord, for the purpose of, my lord, carrying on business, my lord, people start, my lord, open a business account where, my lord, 15 lakhs has been deposited for, my lord, transaction. My lord, all of a sudden, my lord, the banker has freezed the entire account of the petitioner, my lord, only for a meager amount of not more than 5,000. Well, it took already 6 months time. I am not in a position to
What is the disputed amount?
I appear for the Reserve Bank.
Who is for the
My lord,
HDFC?
I am appearing, my lord, I am saying
Yes.
conditional apology. My lord, so far my instruction, my lord, there is a no hold of the entire money, only for few amounts it is under lien. My lord, it has been made under lien, my lord, so far as my last instruction goes, my lord.
So
My
why
lord,
not?
now
Why you are not taken the present instruction?
My lord, my instruction is that there are only 5,000 amount has been under lien, my lord. It's under hold only. Not the entire account is under frozen, my lord.
let it be, my lord, withhold, my lord. That
No,
amount.
how many accounts you are having?
Well, this is 2 or 3 accounts, but this account, my lord,
With regard to this case, how many accounts?
only one account.
Only one account. Correct. Which bank? HDFC Bank.
HDFC Bank.
Yes, madam. So can I record your submission that only the disputed is the 5,000?
My lord, disputed is of 5,000. Overall, my lord, 3 cases are there, my lord. So, my lord, only the disputed amount will be under hold, my lord. Thereafter, my lord.
3 cases are there means?
3 disputed amount.
My lord, 3 different cyber cases, my lord. 3 different, my lord.
1,500.
The copies have been provided to him.
All 3 cases including the 5,000 rupees, or there are different amount in the 3 cases?
Different amounts, my lord. Different
How
amounts.
many amounts are there? That's why I'm asking. That what is the total amount?
My lord, since my learned friend has today made us
1,500. 1,200. Well, aggregating 5, not more than
Aggregating 5,000.
5,000. That is the one.
aggregating 5,000. Yes, my lord. Aggregating 5,000, my lord.
Let it be withhold, my lord. But the entire, my lord, account has been freezed, my lord. I am not in a position to carry on business. And recently, my lord, the Madhya High Court, Honorable Madhya High Court, statement that you cannot disputed amount.
That answer cannot be given, my lord, in absence of an investigating authority, my lord.
That amount I am not claiming. The disputed amount I am not claiming.
Where is the disputed amount? Which page?
My lord, page, my lord, 37, they have stated, my lord, that
30?
it, 37, they have stated that it is blocked,
37?
my lord.
Has been blocked. Yes. When? What is the date of this intimation?
My lord, date of the intimation is, my lord,
26 January.
26 January.
Yes. Then
Then, my lord, I represented so many times to
Hmm.
the bank authorities, they, my lord, did not adhere to my request.
Hmm.
Then, my lord, I have been compelled to, my lord, approach your lordship, my
So
lord.
where is the, you're telling that the 3 disputed amount, where is that? How you came to know about the disputed amount?
My lord, with
I
my
have
lord,
a 39.
with your lordship's leave, my lord,
Page
may I
39, my lord.
get the page?
Nah.
Page 39, my lord, amount hold rupees 1519.
Yes, it is a one amount.
One amount,
Yes.
and my other amount is not been communicated to us, but my lord, not more than 5,000. We have came to learn, my lord.
So you're telling, you're giving the figure just now. Where is that figure mentioned in your record?
My lord, with your lordship's leave, my lord, I believe my junior was supposed to be there, my lord. My lord, may I, with your lordship's leave, present the share the screen, my lord, which shows that the amount which are under
Yes,
hold.
Yes, my lord, I have also got.
Share the screen.
Yes, ma'am. My lord, host has disabled, my lord, I'm not being.
My lord, may I hand over, my lord? May I hand over, my lord?
Yes, my lord. My lord, that copy also has been given by the to the petitioner by the bank.
These 4 amounts, my lord, aggregating not more than 5,000.
Which, where is the 4 amount? That is 1519 is there, and one is 2000, and one is 414.
404.
My lord.
414. These are three.
My lord. I am carrying on business of FL of trouble everyday purchase.
The current account.
Current account, my lord.
The current account or saving account?
Current account, my lord. Business account.
Are you sure?
Current account.
My lord, this is a business.
Current account, yes, my lord. Business account.
It's a current account.
Yes, my lord. Page 39, current account.
Who has given the complaint to you, madam?
My lord, several complaints, my lord. One from the
No, several complaints.
yes, my lord. 4 complaints are one from the Gujarat and another from Bihar. My lord, these are the UPI transactions, my lord. That is why it is being, my lord. Another from my lord Telangana.
The petitioner has filed the present application praying for an order direction upon the bank for defreeze the bank account of the petitioner being current account number 5020066009295 of Bajbaj branch of Bajbaj police. Counsel for the petitioner submitted the petitioner is a businessman and maintaining the current account with the HDFC bank. All of a sudden, on 26th of January 2026, the petitioner has received a message from the HDFC bank that the account of the petitioner has been is blocked. Full stop. Immediately, the petitioner has requested the petitioner for reason of the blocking of the account, and accordingly, the bank has informed the petitioner that the bank has received complaint with regard to the account of the petitioner, and as per the report of investigating officer Manha SHO Vaishali district Bihar, the bank has blocked the account of the petitioner. The learned counsel for the petitioner submit that the altogether altogether the disputed amount is rupees 5,000 only.
My lord, not more than 5,000.
It's not more than 5,000. He submit that the disputed, there are three disputed amount, that is rupees 1519, rupees 414 and
My lord, 125, 345, 1519, 414 and
1519 and
414, 2040.
414 and 2040.
5 amounts. Sir.
Huh?
5 amounts.
Disputed amount is rupees 125, 340, disputed amount of rupees 125, 345, rupees 1519, rupees 414 and rupees 2040. He submitted that altogether it will be not more than rupees 5,000. And because of the said disputed amount, the bank has freezed the account of the petitioner for the last 8 months, due to which the petitioner is not in a position to do the business and to operate the bank account, for which the business of the petitioner is suffering very badly. Full stop. And counsel for the bank submit that the bank has received the complaint with regard to the alleged above transaction, and accordingly bank has blocked the account of the petitioner by informing the same to the petitioner. Had the learned counsel for the respective party, this court find that in the month of January 2026, the bank has blocked the account of the petitioner. After the blocking of the account, the petitioner has several times requested the bank for defreezing the account, but the bank has not considered the request of the petitioner. This court find that the altogether an amount of rupees 5,000 is the disputed amount. In terms of the order passed by this court, the petitioner has also made the investigating agency, on the basis of which investigating of his agency who had made a complaint to the bank with regard to the freezer of the account of the petitioner, the notice has been sent to the investigating officer. In spite of service of the notice upon the investigating agency, none has come forward. This could find that neither the investigating agency nor the bank authority have produced any document that the petitioner is involved in any of the criminal matters. The bank as well as the investigating agency have also not produced any order before this court to establish that they have obtained any order from the competent court for freezing of the account. It is true that since the month of January 2026, the account of the petitioner is blocked, due to which the petitioner is not able to operate the said account, though the account of the petitioner is a current account. Considering the above, this court find that the investigating agency, in spite of receipt of the notice, has not come forward, and the bank has also not received any further information from the investigating agency whether any further investigation whether the account is required for further investigation. Considering the above, this court find that the only disputed amount is rupees 5,000. उसमें calculate कर लेना बाद में 5,000, and as such the bank is directed to keep the disputed amount in lien, and the petitioner is allowed to operate the said bank account. Full stop. It is further made clear that in the meantime, if the bank receives that the account is required for further investigation by the investigating agency, the bank can act in accordance with it.
Grateful, madam.
My lord, may I be permitted to mention one thing?
This is not the mentioning time. Next.
Yes, will draw my lord kind attention to page 14. Your lordship was hearing the matter yesterday. Lord, your lordship would kindly come to page 14 once. Lord, this was a notice inviting tender, my lord, where the tender work was for payment of salaries of these government staffs. And my lord, I was to ensure that the work is done in accordance with.
That's sometimes iPhones create a lot of trouble, and iPhones.
Yes, yes.
My lord, your lordship would then kindly see. On these, my lord, I had participated and I was
cut the
selected.
matter short, my lord. There is a representation pending of my learned friends. That is also one of the prayer, my lord. Kindly see the prayer B. A rate of
Lord,
mandamus
yes.
be issued.
This is
My lord,
there,
we'll
my
consider
lord.
it. Kindly, my lord, direct me to consider it within 4 weeks or 6 weeks, my lord. We'll consider it. Then he can come back. Since
Why you're not releasing all this?
but there are reasons, my lord. Let him then place, and I shall show the cause.
I would, my lord, only indicate to your lordship, my lord, that the notice inviting tender and the work order were in deviation, my lord. That, my lord, the situation which the work order says that you continue to disburse the salaries, but, my lord, when the funds are available with the respondent, I shall be making payment. My lord, in this scenario, my lord, this was not there in the tender, notice inviting
That's
tender.
correct, but see, you are the contractor, correct?
My lord.
You have obtained the work order and you are performing your work.
My lord, the work.
You are
My lord.
performing your work. Now the authority is telling that you continue to perform your work, but due to some fund. If there is a delay of fund, you can very much request for the interest.
But kindly see if I can show that page, which my lord is
Lord, the only difficulty in that event is, my lord, that we had exchanged
28 once, my lord.
My lord, we had
The
exchanged
interest will not be applicable,
correspondences.
perhaps.
Yes.
It's 28.
Page 20, paragraph 7, called clause 7.
Yes.
Work order. My lord, after this, my lord, there had been the exchange of correspondences between the parties. Ultimately, my lord, the work order was cancelled. The work order was cancelled by them.
Request.
I have
this cancelled.
Earnest money deposit is forfeited, my lord. My lord, your lordship.
So if you have in the mid of the contract you have foreclosed your tender.
They have requested for cancellation.
The challenge here is, my lord, that if the notice inviting tender and the work order, my lord, is in deviation, my lord, then, my lord, I am not liable to perform the contract because the work order has not been.
What your challenge here?
My lord, the challenge is the forfeiture of the earnest money deposit should be refunded, my lord.
That is to be decided on merit, on affidavit.
My lord,
not order.
Page 18 months, my lord. As far as forfeiture is, my lord.
Yes, my lord, in that event, your lordship, my lord, would
page 18, clause 13.
Yes.
We see D and E, my lord, once. Sorry. C and D, non-acceptance of work orders since they have requested
Yes,
for
yes,
the
that-
cancellation.
that is-
No,
that
let me
is-
show. Non-execution of agreement. There was an agreement to be executed. Perhaps that has not been.
Yes.
So, my lord, that is why I have cut short the matter. Let the representation be considered. Thereafter, he has a
If you
remedy.
want type dispose of decide. If you want, no, it has to be decided on merit and affidavit.
In that event, your lordship will kindly grant, my lord, prayer B, my lord. Prayer B, the consider
Prayer
of
B.
representation, my lord, page 11, prayer B, my lord. The representation
Yes,
itself
let
is
me
at
decide.
my lord.
Then your cause of action will come now.
My lord, my lord. My lord, the representation, if your lordship sees, is at page 43. The prayer is at prayer B, page 11, my lord.
43.
43, my lord.
Legal notice, representation.
This is the legal notice.
This is the legal notice, my lord. That is not the representation. No.
Where is the legal notice? Representation. The legal notice has been sent by the advocates and solicitors. You not made a representation.
My lord, the page 40, my lord, your prayer P8 is the request for cancellation of work order and refund of EMD. Page 40.
They have cancelled.
My lord.
Yes.
Then
Yes. Thereafter, my lord, page 41 is the cancel with due to immediate effect and forfeiture of earnest money. Your lordship could see page 41, the last paragraph. Hence, as per the terms and conditions due to non-execution of formal agreement, the work order no number dated such and such is cancelled with immediate effect, along with forfeiture of earnest money of the said.
correct.
So, my lord, if your lordship, my lord, would kindly grant, my lord, the if I may pray before your lordship that this petition be considered as a representation.
But there are notices also, my lord. That may be considered. There are 3 notices sent by the petitioner
Where is the
himself.
notice? But there is no
But I
notice.
will-
Let this legal notice be considered.
Yes.
The petitioner has filed the present writ application being agreed and dissatisfied with the part of the order dated 18th March 2026, wherein On the request of the petitioner, the authorities have cancelled the work order of the petitioner with immediate effect. But work order dated 19/11/2025 was cancelled with immediate effect. But the authorities also forfeited the earnest money. And as such, the petitioner has made a request to the respondent authorities not to forfeit the earnest money. The contention of the petitioner is that in the work order there is no condition that the payment will be made as per the availability of the fund under the particular HOA as per the provisions in this regard in the agreement form within bracket WBF 299 and 2911 within bracket close subject to the availability of fund. He submit that the authority have incorporated a new condition in the work order which was not in the tender notice. And as such, the petitioner was not agreed with the terms and conditions and requested for cancellation of the tender work order issued to the petitioner. Though the authorities have cancelled the work order of the petitioner, but have also forfeited the earnest money. Petitioner submitted the petition has made request to the authorities through the learned advocate on 4th of April 2023.
42 also you have
There is a letter, Milord.
Where
That is and Milord. That's only known as
made a request to the authority, not advocate karo. Petitioner has made a request to the authorities on 19th of March 2026 for consideration of the request of the petitioner for not to forfeit the earnest money deposit by cancelling the work order, but the authorities are not considered the same. Counsel for the petitioner submitted, the petitioner will be satisfied if this court direct the authority for consideration of the representation of the petitioner dated 19th of March 2026, followed by the legal notice dated 4th of April 2026 as early as possible. Consult the police. Learned counsel for the
4 weeks.
Learned counsel for the respondent submitted if this court will dispose of the writ application by directing the respondent authorities for consideration of the representation filed by the petitioner dated 19 March 2026, sufficient time may be provided so that the authority will take appropriate decision in accordance with. At the learned counsel for the respective parties, for the record, this court find that the petition has made a representation to the authorities on 19th of March 2026, followed by the legal notice dated 4th of April 2026 with the request for not to impose the condition for forfeiture of the EMD, but that has not been considered by the authority. In view of the above, who is the competent authority?
Competent authority.
Executive engineer or superintending engineer? To whom you have given the representative? Executive engineer.
Executive.
The executive engineer.
Responding to Manu.
Executive engineer, Murshidabad Division, PHE. Direct the respondent, the executive engineer, Murshidabad Division, the respondent number 2 is directed to consider the representation dated 9 of the petition dated 19th March 2026, followed by the legal notice dated 4th April 2026 within a period of 4 weeks from the date of receipt of this order, and to pass appropriate pass a reason in speaking order and to communicate the same to the petition within a week thereafter.
Personal hearing be granted.
If required, the respondent number 2 shall also provide the personal hearing to the petitioner.
Without advocate.
With
Obligement.
Obligement.
None. Why, my lord, I appear for the state.
Time for the petitioner, madam.
Yes.
On last occasion, my lord, this is a kidney transplant matter, my lord. The petitioner is a stage 5, my lord, kidney disease petitioner.
Yes.
My lord. My lord, on last occasion, they have filed one report, my lord.
Correct.
And report says that, my lord, the committee did not consider because, my lord, kindly peruse the report, my lord.
Yes, as per the statement of the donor, her husband was staying in Sonari.
Yes, your lord.
At Jamshedpur for the last 10 to 12 years and did painting works at the recipient house. As per the statement of the legal guardian of recipient donors, husband did not work at their house and they were staying in Sanchi. Hence, the statement between the donor and the recipient is not beyond the reasonable doubt. Yes.
Yes, your lordship.
So,
This is the, my lord, the committee's report. And thereafter, my lord, kindly peruse the, my lord, page 11, my lord, point number 7, my lord. Yes, my lord. Page 11 and 12, my lord.
yes.
11, my lord, whether there is any middleman or tout, my lord, the police verification report is in.
Middleman.
Yes, my lord. And on that point, my lord, I have take specific instruction regarding that. The petitioner's brother has a shop in Sonari, my lord. And Sonari and Sachi is a, my lord, adjacent place, my lord. Petitioner donor's husband working, my lord, Sonari at the shop, my lord, not the house of the, my lord, petitioner, as per the petitioner statement. And my lord, page I am placing, my lord, page number 12, my lord. The committee has not considered the, my lord, statement made in the affidavit, my lord, also, my lord. My lord, in this juncture, my lord, my prayer, my lord, considering the, my lord, Sunita Khara, my lord, I am praying, my lord, to revert back the committee. They may again, my lord, call the petitioner, and this is a factual disputes, my lord. They can clarify these factual disputes.
No, but as per the statement, the verification authorities have recorded the statement and mentioned that the total statement is different as per the statement.
Yes, my lord. The petitioner statement.
Their house.
Petitioner statements also the same, my lord. Petitioner
their house and
petitioners work in the, my lord, shop of the.
But you have now making out the case.
No, my lord. They have given.
After the report, you might have been make out the case, but what is the actual? See, what is the purpose of examination of the donor and the
relationship
guardian by the? So establish with regard to, because with regard to the involvement of the middleman and amount and commercial, that is the police authority that
Police
considers.
gives specific.
But that's why the verification committee has examined you. On
lord,
examination, it is found.
My lord, this statement is not completely wrong as per the petitioner. This statement is completely.
Then I will call for the recording.
Yes,
I will record then recording.
Yes, your lordship. My lord, can my lord kindly give me a give me a copy, my lord.
I will see this recording. I will let the matter come on Tuesday. Then I will see. If it is varied the statement in the recording, then
the petitioner statement, my lord, may I am already, my lord, submitting before. I am repeating statement, my lord.
What you are stating, what you are submitting before this court, telling that your statement before this court, submission before this court. Now this is the statement is not correct. It is
no, my lord. I am not saying that this report is completely wrong, my lord. The petitioners, I have, my lord, they have message in WhatsApp, my lord. They have specifically mentioned they have a shop in Sonari.
Okay, let me see.
Yes, my lord. They have shop. The petitioner's donor's husband work in the shop, not in the house, my lord.
Landed Council appearing for the state has submitted the report wherein reveals that as per statement of the donor, her husband was staying at Sonari of Jamshedpur for last 10-12 years and did painting works at the recipient house. Full stop. As per statement of local guardian of the recipient donor's husband did not work at their house and they were staying at Sanchi. Hence, full stop. Hence, statement of relationship between the donor and the recipient is not beyond reasonable doubt. Accordingly, the committee has not recommended the case of the petitioner for transplantation of organ as requested by the donor. Full stop. Learned Counsel appearing for the petitioner submits that the petitioner has got the information and the counsel for the petitioner submitted the counsel has got the instruction from the petitioner and submits that the donor has stated before the authority that he is not working in the house, he is working in the shop of the recipient.
Which is at Sonari.
Which is at Sonari,
Jamshedpur, my lord.
Sonari, Jamshedpur, and not in the residential house, but that has not been recorded. Full stop. Learned counsel appearing for the state has submitted the pen drive in which the recording of the statements made by the donor, recipient, and the guardians have been recorded before at the time of their verification by the verification committee. Let the matter come on 18th August under the same heading. Huh?
Wisdom on Monday, my lord. I have some difficulties.
Okay, then you fix on 20th.
28.
Grateful.
Well, Lord, may I get a copy of my lord video recording?
Let me see.
Then I can also, my lord, assist.
I have infrastructure to see that.
I'm grateful, my.
You might have been gone through my judgments. If I find
My lord,
there is a
I-
discrepancies, I am recording the total statements
Yes,
in
my
my
lord.
order.
And my lord, in your order, my lord, kindly peruse the order of my lord passed in Sunita Khara, my lord.
Yes, that's a
And-
see the
and my
statements
lord,
have been
there is a
recorded.
specific.
Statements have been recorded,
Yes, your lord.
which is the contrary to
Lord,
the
para
statement made by the
27, my lord has recorded that the court finds that verification committee has not considered the
correct.
statement.
That's I'm telling.
Yes.
I will see.
Yes, your lordship.
Yes, next.
Gratefully, your lordship.
But this my application, this is my affidavit of service and affidavit and reply already been sent.
আপনার এটা কোনটা?
Item number 6. Oh, sorry. Sorry. I should be seven.
Lord, I appear for the state.
We appear for the
But
petitioner, my lord.
I'm led by Mr. Rajdeep Majumdar, my lord. He's on legs, my lord. I can start, my lord, today.
What is the matter?
This Shorai matter, my lord. Shorai,
Yes,
this
yes, yes.
Mr. Basu leading in this matter
Yes,
was.
So, my lord, yes, my lord, they completed the submission on the last date.
Yes.
We had taken some time to seek instruction. So, my lord, the objection that they've taken to the impugned memo with regard to.
Before my learned senior friend begins, for only one development post the filing of the writ is that, my lord, the fire recommendation certificate has been issued to me after the writ has been filed. So only to bring that on record, my lord, and the fact that we have made already been fire compliant, we have just produced a supplementary affidavit, my lord. I'm serving a copy. It's just after the writ, only that fire license, fire recommendation certificate has been issued.
Fire recommendation.
Recommended. That is the step towards the. Now, my lord, I'll.
Now, my lord,
Yes.
it is my turn.
Yes.
Your lordship can remember their main point was 2 points they have argued. That SDO doesn't have jurisdiction to issue the impugned memo because it is the discretion lies with the district magistrate. This is number one. And second, register under the Sarai Act should be granted as a routine matter of routine. These are the 2 points they have argued.
Yes.
Now, my lord, it is, my lord, my question before your lordships today. My lord, the hotel or my lord, the place
Yes.
who doesn't have the license, whether they can take benefit of this act or not. This is number
Yes.
one. Number two, your lordship will find the jurisdiction of the SDO. The impugned memo, if your lordships kindly come once, act 102. Your lordship will find annexure P1 102.
Yes.
Lord, kindly see, it's very, very important. Lord, kindly see who has actually taken the decision, whether the decision taken by the SDO or the decision has been taken by the DM. Lord, kindly see, closing down of lodging operation of Sanchari Resort for operating without Sarai license, reference memo number 44 by C. This memo, Lord, they have never annexed. Lord, kindly see this memo once. But before that, Lord, kindly take this memo. The district magistrate, he himself conduct an inquiry prior to Lord, issuance of this memo. Lord, kindly see this. On basis of which, Lord, the decision was taken by the district magistrate. देखिए देखिए भूल चले गए हाँ এটা আগে But this 25th memo, but kindly see, this was issued on 25th May, where it is by the district magistrate. It says, whereas certain issue have been emerged regarding operation and utilization of the property situated on plot number so and so, so and so, so and so, established as an old age home on government land belonging to the collectorate Birbhum. And whereas the question have arisen regarding the process of leasing and licensing of the said property, will not kindly mark it here. Execution of the agreement, supplementary agreement, approval of construction, and so and so, the alleged commercial utilization of the premise, and where it is considered necessary to inquire into the factual, legal, and administrative aspect of the matter, protection of the government interest of the public property. Then, now, therefore, the following committee has been formed, detailed inquiry into the matter. Then the inquiry committee, your lordship will find the committee may inspect the report records, conduct the field inquiry, obtain report from from concerned authorities, and examine any person as deemed necessary. The committee shall submit a report on 5th of June. So this committee was formed by the DM himself.
So you do one thing, if you are having all the documents, then you file a
We can do so. We can do so. Well, it's on record. They have not. They have only annexed
they can get also the opportunity
We will
to
do
deal
it.
with it.
We will do it.
This documents for the, I am getting it for the first time.
That's
not
what
com-
telling.
Yes,
They are telling that it has been. So you.
And section 5 is very clear, my lord. Kindly see the section 5 of the Sarai Act. It says without the license you cannot operate.
Correct. That's why you give all this.
I have a very good report.
General Causes Act is very clear. Very clear. Your lordship knows better than me. But I am new in this field, but your lordship has a vast experience.
You also not that. Okay, no problem.
Only that, my lord, there is a threat that
It already stopped.
kindly
Lodging facility. It has been the lodging facility. They cannot do so without the license. Admittedly, they don't have the license.
my
Other facilities they are enjoying. So let them enjoy the other facilities.
They are not disturbing your
Yes.
possession.
No, he's saying, he's making a submission.
He's telling that lodging facilities you cannot do.
Cannot do until unless you get license.
It's not there.
My lord, my point is that, my lord, I don't require this license, my lord.
So
That is
the license.
That's why let them file the. How soon you will file the affidavit?
Within 2 days we can file.
my entire hotel is a hotel. Lodging is the main income
Let
from
them file
that.
within a week. You take exception. I am fixing up
But
to
the question is whether without the license you can operate.
My lord, only till then, my lord, kindly grants a protection because no further steps would be taken for the impute. Status quo, that would be fine. That would
They cannot.
my lord, that is the difficulty.
So then
That is giving it. That is giving
the license. Not they are telling the license is not there. How the board can
Kindly promise me to make this submission, my lord.
the council for the state, Learned AAG, relying upon several documents. This court find that instead of placing the document in piecemeal, it would be better to direct the state authority to file the affidavit in opposition by disclosing all the documents which the state is relying on. Accordingly, affidavit in opposition
Within 7 days.
within
Because they
a
have to-
week after serving the capital and counsel for the petitioner, the petitioner's liberty to file reply, if any, within a week thereafter. This is the matter. आज कितना तारीख?
My lord, kindly grants me protection in terms of prayer H of the writ petition, my lord. My lord, we'll come with a very short reply, my
1st
lord.
of September within 5
Declare.
minutes. Within 5
My
minutes.
lord, kindly see the spread.
Come, I am fixing it. I am giving the short date. You come. I will decide the matter. उसमें लिखो ऊपर supplementary affidavit filed by the petitioner be kept in the
Yes, ma'am. This is my application. This is my affidavit of service and this affidavit of reply already have served. No, that's the affidavit of service. But a very short matter is this, my lord. The husband and father of the petitioners was a sweeper in the respondent company. That is the National Insurance Company. Since 1989, expired during his service after 13 years serving, May 4, 2002. Now, my lord, these petitioners come before your lordship, my lord, with a prayer for their ignorance to pay the death benefits, that is the gratuity and the provident fund. In their opposition, they have stated, somewhere they have stated that they have paid, but since they have they have paid, then since they that no, we don't pay, but we have
appearing for the authority.
not appearing. Mr. Guddu Singh.
Huh?
Mr. Guddu Singh is appearing. So far, my lord, is opposition.
Opposition filed?
Yes, opposition reply, everything complete. Guddu
When it
Singh.
was filed?
Opposition long back, and reply filed within time. all are.
Opposition is not right.
Yes, I have served. I don't know it's filed or not. It is served.
It is not filed.
Well, it is served on me. May I, my lord, make a communication to the learned advocate and my lord kindly fix the date and one that will be.
None appears on behalf of the respondents.
Wait for the petition.
In spite of service of notice, the petitioner has filed affidavit in reply, but this court finds that no affidavit in opposition on record.
Though it has been served upon me.
Affidavit of opposition, but the same has been served upon the petitioner. Learned counsel appearing for the petition. In view of the above, the petition is directed to inform the next date of hearing to the learned counsel appearing for the respondent to file the press affidavit of service. It is made clear that on the date fixed, if the respondents fail to appear before this court in spite of service of notice, the writ petition will be taken up a hearing in the absence of the respondents. This is the matter.
I'm for the respondent, my lord. My lord, I pray 1 week's time, my lord.
Where is your affidavit?
My lord, it has been affirmed. I have served upon.
Yes, where it's not filed.
My lord, kindly takes on next week.
Okay, get it then.
Yes.
Learned counsel for
They need not to serve.
The petition has filed affidavit of service and affidavit in reply. Let the same be kept with the record. But this court find that the affidavit in opposition is not on record. Full stop. Now, counsel for the respondent submit that he will file the affidavit in opposition in course of the day.
No, my lord, next week. My lord.
Within a week. Full stop. He prays for time. Accordingly, for the interest of justice, case is adjourned. Let the matter appear on 25th August.
Great.
25th August.
Under the same. Next.
My lord, I am appearing for respondent numbers 4 and 5 in the matter. Because of a medical urgency at my place, I have given my brief to my junior who's there in the matter. She can assist your lordship otherwise.
Lordship, on the last occasion, your lordship asked for a report from
the bank.
Bank company. Yeah.
Yes.
So there was no direction for filing any written report, my lord. Instructions were sought for, my lord. My instructions are that the petitioner, the receipts against the petitioner could produce receipts, valid receipts only for the amount of rupees 28 lakhs. So for that reason, this amount the bank agreed to pay. For the rest of the amount, the bank is not aware. In any event, those receipts also which the petitioner is relying upon, my lord, ICICI Prudential's receipts, however, it contains the seal of the bank, my lord, which is definitely cannot be of insurance company, my lord. So there was also fault on the part of the writ petitioner, my lord. But still, bank as a bona fide gesture, the receipts against the receipts bank has agreed to pay those amount against which the petitioner has produced a receipt. Remaining amount, the bank cannot take liability because whether it has been paid in cash or under which capacity to that officer, that bank cannot.
My prime challenge is I am agreeable to take 28 lakhs, but bank is directing me to execute indemnity bond with my draconian clauses. Right? So they have already concluded investigation. During investigation, internal investigation, they offered me 28 lakhs with execution of indemnity bond. And after, kindly, if your lordship takes up page number 36.
He can pursue his claim for the rest amount against that person to whom he has paid the amount. Bank cannot be held liable for those amounts.
With regard 28 lakhs, if you wanted to release that or pay to the petitioner, whether the indemnity bond you are still harping upon.
My lord, yes, because bank cannot acknowledge any liability, though it was beyond the petitioner could not have randomly handed over checks to a person.
Indemnity. I am telling you, they are not asking to give the bank guarantee or on all those things.
Yes.
Indemnity is only on the bond paper with the two sureties that in case if any in future, if any dispute will arise, then he will you have to refund them.
These are not the clauses.
Kindly come to the F. Kindly come to the F. Indemnity like this, I don't know what are
Yes,
the.
I do not have any problem with these
Correct.
conditions, but the condition they're imposing, I have not disclosed this matter to any third party. If disclosed, they will retain that amount. But these are at page number well, at 132. But 31, paragraph number 2, and page number 32, paragraph number
Declare
3.
that they are not filed. They have not filed with government agency or court any type of action report against the ICU in relation to the disputed transaction, except the government's matter. The claimants have to take whatever action. Madam, there will be a simple indemnity. If you are ready that you are satisfied with the receipts, you accept it, you release it with the simple indemnity that in future if any claim has come with regard to the said amount, then the petitioner has to pay the return back the said amount. That's all. That is the indemnity call. How you can restrain now? You cannot use, you cannot do, you cannot this.
So he has authority to produce the agreement, my lord. There is no a blanket restriction, my lord. If what the clause.
Now, kindly come to the
clause
paragraph, page 31, paragraph 2. Paragraph 2. The claimant declared that they are not filed with any government agency or court any type of action report against the ICSM in relation to the disputed transaction except the government. Once he received the amount,
Your Lordship, the bank's contention is only that the bank is as a bona fide gesture, whatever it's. I'm not going into that. He's paying 28 lakhs.
Correct.
Now, whatever his remaining claim can be, that against that person who has committed any
claim means what remain?
He is claiming some 32 lakhs or lakh.
Kindly come to the prayer. Prayer A, only 28 lakhs, 1,241. This is only claim.
Yes.
Or their grievance is that you are imposing the conditions with regard to that. They are agreed with the conditions. So what you take the instruction with regard to this amount, if you are ready, then he will give the indemnity. Yes, in future, if any claim has come with regard to the said amount, legally claim, then the petitioner will have to deposit the said amount. That's nothing else.
And they will not
That
claim.
always any department also in even succession certificate also you have to give the indemnity.
And they will not claim any further amount or any further claim in respect of this present dispute against the bank, my lord. This is what bank's contention is that.
I do not have any problem with
Yes,
that.
So you are telling that another amount, what another amount?
But my total claim was 38 lakhs.
You are fully satisfied with the
28 lakhs.
I will record that.
Yes, madam.
I will record that.
Can you do that?
And he will give the simply identity indemnity bond stating that he will not claim any further amount, and in case the bank received any claim with regard to the said amount, the bank, the petitioner will appear before the bank and.
Yes, madam. Can you do that?
My lord, with my learned senior's permission, I am submitting on behalf of RBI that the ombudsman has closed the complaint on 31st December because the bank is willing to refund the money. Therefore, the bank does not have any deficiency in service, my lord.
The grievance of the petitioner in the present date application that the bank has not bank is ready to return an amount of rupees 28 lakhs 1,241. क्या बोला? Is to refund this amount subject to execution of the indemnity bond by the petitioner, but in the indemnity bond the condition which the bank has imposed, that is not acceptable to the petitioner. That is not acceptable to the petitioner. Learned counsel appearing for the bank submits that the bank is intending to the bank directed the petitioner to execute the indemnity bond so that in future the petitioner shall not claim any further amount with respect of the said disputed amount. disputed amount. Full stop. Learned counsel appearing for the RBI submits that though the petitioner has made the complaint to the RBI, but subsequently the complaint has been closed on the ground that the bank has informed the Reserve Ombudsman that the bank is ready to pay the amount of rupees 28,01,241 to the petitioner. Full stop. Heard the learned counsel for the parties. This court find that the bank in the indemnity bond, the bank is intending to incorporate the following conditions. Where are the conditions?
The conditions are at page number 31, 32.
Following condition, that is in this 31 paragraph 2. ঠিক আছে? 31 paragraph 2
and 32 paragraph number 7, 8.
7 and 8. This one. ठीक है? Full stop. This court finds that the total claim of the petitioner is 38 lakhs. 38 lakhs. Now the bank is ready to settle the dispute for a total amount of rupees 28 lakh 1,214. And the petitioner is also ready and willing to accept the said amount being a full and final settlement amount. It is specifically stated by the petitioner on instruction that the petitioner, if the bank will pay the said amount of rupees 28 lakh 1,241, comma, the petitioner will not claim any further amount from the bank with respect of the said the disputed amount of rupees 38 lakhs. Full stop. Consider the full stop. This court finds that the bank intending to impose certain conditions as mentioned above. If the bank is going to settle the dispute with the petitioner and ready to disburse the 28 lakh being the full and final settlement, this court finds that the condition which the bank intending to impose upon the petitioner by way of indemnity bond is not justifiable. And as such, the bank is directed to pay this amount of 28 lakh 1,241 to the petitioner on furnishing the indemnity bond by stating that number one, semicolon number 1, the petitioner will not claim any further amount other than the said amount. Number 2, the petitioner has received an amount of 28 lakh 1,241 being the full and final settlement. Full stop. Number 3, if in case any claim received by the bank with respect of the said amount from any third party, comma, the petitioner will refund the said amount to the bank.
The petitioner will not initiate any further proceeding on this dispute, my lord, against the bank.
It is full number next. As the petitioner has agreed to accept the total amount of rupees 28 lakh 1,241 being the full and final settlement, comma, the petitioner will not initiate any further proceeding against the bank with respect of this aforesaid claim. In view of the above, full stop. If the petitioner the petitioner is directed to furnish the indemnity bond within a period of 1 week from date, if the petitioner submit the indemnity bond to the bank, comma, the bank shall release the said amount immediately on receipt of the indemnity.
Point number 3, petitioner will refund the amount to the bank.
If any third party claim is there.
Okay.
Grateful to Lodge.
Yes, I'm for the petition.
Yes.
The service of everything.
Third. डिस्पोज ऑफ वाला गाइन इससे पहले वाला डिस्पोज ऑफ हो गया. Yes.
Disability application arisen out of the because of non-implemented of act, that is BARDS Act in short, banning of Unregulated Depository Act 2019. The jurisdiction where to
act is in force, but the court is not, the government of West Bengal has not
Not constituted a court.
any
A court or board? What is the act? You have an act. Who are you?
petition.
Who are you? How the petition is affected and how the petition is asking for this mandamus?
Yes, I'm clarifying. Your petitioner father was the employee of Cell, and that
Banning of unregulated. This scheme.
Authority of India.
This is a scheme. Scheme is framed under which act? This is a scheme. Banning of unregulated deposited scheme Act 2009. Okay, Act 2009.
2009.
Yes. To whom you serve? Who are the party? Because this is to be the state has to be heard. You are appearing.
But answering this for the Steel Authority of India, man, not the state.
No.
State is also a party.
No.
State is a party, but
No. They wanted for implementation of the act. So you have to give the answer whether you have constituted the court or not under section 9 or 10.
7.
7. So this is you have to give answer. What instruction? This is something.
Synopsis of the case is that father of the petitioner, being the member of the respondent number 4, Steel Authority of Employees in Cooperative Society, deposited some money, invested, being the voting member of that society, invested some money. After demise of after his death, your petitioner asked for refund back the money, being the nominee
Of the share. Of the father was
deposits.
Father was the
Depositor, being the member.
Being the member of the.
Because society cannot take the deposit from the outsider.
Correct.
Apart from the.
He was the member of the Steel Authority of India.
Your petitioner is not a member.
No, his father.
His father was the member.
Member of
Steel Authority of
Steel
India.
Authority of India.
Number
Correct.
4.
Correct.
Rather, without refunding back the deposited amount, rather they have taken further deposit from the non-member, who is your petitioner now.
The son has also deposited. After the death of the father.
Yes.
But he was not the member of the respondent number 4.
Yes.
Then
and your petitioner is barred by the.
That was accepted.
That was accepted, and they have.
So now you wanted
they have declared.
Now you wanted to return back the membership.
Nominal member. They are declared as a nominal member.
Correct.
Nominal member is nobody. But your petitioner is barred by the Multi-State Cooperative Society Act. Could not move the CRCS because your petitioner is not the member.
Correct.
That's why we have opted for the BARDS Act. Get relief from the BARDS Act. In the BARDS, when we have prepared the drafting and filing for the BARDS Act, who will be the authority? Section 7 and 8 is clearly evident from that act that there is no court has been constituted by the government of West Bengal.
No, court is not there. There is a competent authority. That's what I'm asking.
Competent
authority. As per section 7, the government has to appoint a competent authority for this purpose, but not below the rank of the secretary. One or more member of the authority constitute of one or more member of that.
There is no notification, and they have already replied by against my RTI.
What they have stated. So you are not challenging the order. The order passed by the Central Register of Cooperative Society. You are not challenge this order. Kindly come to the page 84.
I'm barred by the MSME, Multi-State Cooperative Act. I'm not the member. Without, when I'm not the member, I cannot challenge against the order of CRCS. Only member can challenge.
So this proceeding was initiated? Who has initiated this proceeding? The Steel Authority of India Cooperative Society so is registered so. A number of complaints were received from the members of the society alleging various irregularities. So what is your actual prayer?
My actual prayer to constitute an appropriate authority or court.
That is different thing. So how you are being affected? What is your actual prayer before the Steel Authority of Sale?
Because your petitioner is there is a huge forgery by the Steel Authority of India. Your petitioner is going to file the petition under Section BARTS Act.
For what?
For return back and attachment of the property. BARTS Act provides.
That's why you have made a request to the Steel Authority of India for return back of the amount which has been deposited by your father being a member of the sale. That's correct. And subsequently some amount received from the non-member. You have made a request. So what is that? What is the reply?
No reply.
No reply. So that's why if you no reply, then as per your case, if the no reply, then the competent authority, you have to go to the competent authority. Yes. And the competent authority not been constituted by the government. That's why you are making a prayer for appointment of the competent authority. Yes. Correct. If may, if not, then who? If you will not appoint the competent, then the writ court. Yes. Correct. If you are telling that may, so you are reluctant to appoint the competent authority, then the burden upon the writ court to decide. If the writ court to decide, then you know what the writ court will decide. Correct. To take instruction whether you are going to appoint. If you are not going to appoint, then the writ court, this court has to decide the grievance of the petition. This court find that and land council appearing for the state prays for time to take instruction. Accordingly, case adjourned. When? Within week or?
No, my lord, fortnight.
Let the matter appear on 27th August. Affidavit of service filed by the petitioner be kept with the.
My lord, 27th I will not be here.
You are outsider?
Yes.
When you will be back?
Before 27th.
25th? 25th?
25th.
Within 10 minutes. Yes, next.
In Lordship, I beg to appear on behalf of the petitioner. This is relating to, my lord, this is relating to, my lord, the appointment of, my lord, the Vice Chancellor of Vishwabharat University.
How this court is having determination?
No, my lord, the exchange of evidence is done, and my lord, we have prayed for, my lord, for enlistment. Lordship was kind enough to enlist it for hearing.
Now, whether this court have a...
Yes, my lord, jurisdiction is there, my lord, because since it is 2025 matter.
Matter?
Yes, my lord.
Affidavit is completed?
Yes, my lord. Affidavit completed as far as, my lord, the private respondent is concerned. Back. So, at least on 3 occasions, time filed their affidavit. They are yet to file any affidavit. Lordship, kindly see the order dated 18/5/2026. Here also another opportunity was afforded by the Honorable Court for filing, my lord, their affidavit. My lord, till today, my lord, no affidavit, nothing of this sort.
My lord, now I am
Before that,
here. The affidavit will be filed within 2 weeks.
Before that,
I really appreciate that. I have
The affidavit is completed. How this court can let? I am releasing it.
No, my lord, the time of at least on 3 occasions time granted to the Union of India, my lord.
On the last occasion, when the matter appeared, Lordship, it was said that the matter will be fixed today for hearing. In the meantime, the Union of India may file their affidavits. Now, my lord, with the rigmarole of events post-May, and then change when I have become now incumbent. Now, Lordship, I have come into this matter, but the affidavit will be ready within 2 weeks. We have used our good office. And so, Lordship, one more opportunity may be given, Miller, so that, it can come, the matter may be brought to a logical conclusion, because we are the answering respondents, Lordship, and allegations have been leveled against us with regard to appointment of the Vice Chancellor, where the petitioner is championing for the cause that he was the person concerned, and the person who has been appointed is not the person whose appointment was justified on array of allegations. Now, be that as it may, Lordship, whatever allegations has come from their side, Millard, let us come on affidavit. I beseech your Lordship, one particular chance be given, Millard, and let it be kept for hearing, Millard. I shall come back.
Only my prayer is, let them give 1 week time and 1 week to reply, and matter may kindly be fixed at a particular point of time. And they will ask time. If I will give 1 week
No,
time.
at least 1 year time, meanwhile he'll have this purpose. Lordship will decide. This is my I'm beseeching, my lord.
Learned Council appear. Yes, Mr. You are appearing for?
For Lordship, respondent number 2 and 1 and 2.
Respondent Council appearing for the respondent
1 and 2.
1 and 2.
Maybe 1 and 2.
Hey, I am releasing it because it is not ready for hearing. How it can be?
Because they failed to file their affidavit.
May failed, but it is not ready.
Failure means tantamount to filing the affidavit. It is their the failure.
But can we see the 15th August, the 18th May order? It
Yes,
is
my
not
lord.
that it will be taken.
If the union chooses to file affidavit, it shall do in the meantime.
Okay, I am giving the direction and releasing the matter to place before the
court. So, after a long, the period, after a long persuasion, Lordship was kind enough to fix it. And we are waiting last 1 year.
This court has to go by the determination.
This is to be treated as, the mature for final hearing.
This court is not having the determination according the case, the WPA number 14072 of 2025 is released from the list of this court with the liberty to mention before the appropriate.
So the question of affidavit may kindly be directed, my lord.
No, you mention that. Yes, next.
I'm ready.
Deeply
My lord.
Deeply.
Yes. Item number 11, I beg to appear on behalf of the petitioner, my lord.
Yes.
I am for the respondent.
My lord, it's a matter of appointment of legal guardian.
Yes.
My lord, kindly see the order dated 28 April 2026.
Yes.
Of your lordships.
The contents are very. Yes, what is the instruction?
Lordship, I got the instruction from mail, Lordship, that there is a policy under the National Trust Act 1999 that the Lordship autism, in respect of autism, cerebral palsy, and mental retardation and multiple disabilities, there is a provision, Lordship, under the TM that anybody after death of his or her parents, anybody.
That's why you are not taking step. That's why I put whether you're taking the decision.
Lordship, Lordship directed to us, then
what? Then directed, then you will keep pending for the last several years because you're not appearing before the court.
Last occasion, Lordship, I am apologized after that.
So what is your instruction?
Lordship, we are ready to take the decision, Lordship, if Lordship directed us.
So you do one thing. I am recording your submission. How you can where is your application?
Yes. Application at my lord. Page 30, P4. They have replied also, my lord. As per National Trust Act, there is no law to appoint in respect of schizophrenia is concerned.
Yes.
So, in absence of law, that's why, my lord, I am approaching this honorable.
Where is a medical document?
Yes.
Chronic schizophrenia.
Yes.
65%.
Yes. ma'am.
Yes.
And where is the act? Give the act.
National Trust Act
Hey, mental
1999.
retardation act.
I'm
अच्छी की.
National Trust Act, madam?
1999.
Yes, I am.
That is not covered by the schizophrenia patient, Lordship.
Yes. Hey. Devin, acha.
Mental act है ना, mental retardation.
Madam,
Disability.
I am giving that. No, no, no. Schizophrenia is not called. Page 17 is the
Page
17 is the certificate, man. Disability.
70.
17. One.
No, act, which?
Act I am giving you, Lordship. April order has clearly, my lord has already discussed about
Person with disability means suffering from any condition relating to, but he is not coming under that condition.
Yes, sir.
Suffering from severe mental disability, multiple disability.
Yes.
So it's not coming under that. So
that's why I am seeking before your lordship. I have also submitted judgment of Honorable Madras High Court, my lord, on a similar circumstances. The G. Babu's judgment, my lord.
So how you are asking for this court to appoint the guardian? Under which provision?
Because there is no law, my lord. There is no law. That's why I am seeking before your
You
lordship.
can, who are you?
I'm the sister of the
So you can go to the mental health act.
No, my
before
lord.
the,
At the present circumstances, 2017 Act is concerned.
that's why where is that act?
Yes. On the first day, I have this question was fallen from your lordship,
Yes.
and I have satisfied my lord. The kindly see the judgment, my lord.
Now where is the act?
Yes, I am giving. Along with the repeal provision. It is to the Mental Health Act. Mental Health Act.
Which section you are referring?
Already repealed, my lord.
Which act?
Mental Health Act.
Where it is repealed?
Yes.
Where it is repealed?
Yes. 1987 Act. 1987 Act has the content to appoint the legal guardian by the district district judge.
Correct.
But 2017 Act it has been abolished, my lord.
Where which notification tells indicate that where it is repealed?
Well, let's see the repeal provision of the repeal, my lord. Now, my lord, kindly consider the para 17 of this judgment. And your lordship will be clear for there is no law regarding
Yes. That portion, my lord, 70, paragraph 70. Copy. Firstly, I have already given this judgment to your lordship, wherein the similar circumstances, the petitioners, here is also the petitioner brother is suffering from benchmark disability, approach the Honorable High Court and Honorable High Court please to.
That is the problem, but the state is not cooperating with the court. No, they have to come whether there is any rules have been framed by them or not.
Not
My
yet,
lord, can you directly
If
direct
lordship
them
directed.
to appoint, they will
comply.
consider and
They
appoint.
will, that's why if I direct, then tomorrow they will come, it has been repealed, we have no authority, then what will happen?
The authority.
That's why this court is not believing on the consideration. The court want to,
Yes,
the
yeah,
actual.
absolutely,
So if
absolutely.
today, already for the 1 year you are facing the matter, then I will refer that tomorrow, after 6 months, they will dismiss the, what will happen?
What will happen? Absolutely. I would again suffer.
Yes.
On the earlier.
Only say I will consider. But if there is no provision on the act, what the court will do?
This was the last.
No.
This was the last report they have submitted. Nothing reiterated my submission also. Nothing more. Which has been I have already canvassed in my writ petition. Yet a moment. The problem is here, my lord, I don't have any way out where I shall go.
That is the problem.
The judgment which I have cited, my lord, the judgment gives the authority to the honorable court to direct the petitioner to be appointed as a guardian of her brother.
That's correct. But
And absolutely similar circumstances. Absolutely similar. Similar circumstances.
See, appointment of guardian is not a big thing. The thing is that if a person is suffering from a schizophrenia, if a person is appointed, so what is the further cause of how you maintain the account, where you submit the report, who will control you, who will control the audit of the person, the person who is suffering from schizophrenia? Because as per the Guardianship Act, there is a provision. Now the mental health, if it is repealed, so where you will submit, whether the court will continue with that.
District judges, the guardian of any.
Yes, Mr. Vasu, please address this.
I was telling him that take adjournment and prepare yourself. That is
Yes,
what I was-
because appointment, if a appointment, what for the appointment? He is suffering. He is entitled to get some benefit from the government. He get some benefit. If he will get the benefit, suppose he get the benefit of lakh rupees. So that lakh rupees you have to invest or spend the same for the purpose of the treatment or for the purpose of his livelihood. So you have to maintain each and every piece of expenditure. Then you have to submit the audit. It is not a simpliciter. You have to submit. If tomorrow something has happened, the more amount and misappropriated, who will be responsible? How the guardians will be tackled? That is the problem. That this judgment has not. And last day I have gone through. This judgment has not taken care of that part.
My lord, our Honorable High Court also deals with the similar circumstances.
That's when the
my lord Justice Amrita Sinha has also said
so where you submit the audit, Yearly or 6 months or half yearly or 2 years.
Law silent in this.
So if silent, so whether this court can create a law directed to submit to the district judge or submit to the district magistrate,
65%.
or this court cannot continue this matter.
Absolutely.
Then
Indeed, so.
52.
if it is civil, okay, it can be done, and you can file, and there is a department take care of it. But how in the appellate side? That you think on that, I will also research on that. The new thing has come.
Kindly consider the.
I will see. There is no dispute regarding you. Your brother is suffering from. You are able to take care of it. You can be appointed as a guardian. But till that is no dispute with regard to that. If you have been appointed, we don't know. The court don't know. The state don't know. What is the benefit the person will get? What are the amount you will get? So how you will manage with regard to the accounts and all these things? If suppose there is an allegation against you tomorrow, you have taken the amount and misappropriated, who will catch hold of you? Which, how? And how you maintain the account that?
The hand of the pensionary authority.
How? Because he is suffering from schizophrenia. You are the guardian. So there is no control over there. There is no control upon you. So who control the guardian? Who control the guardian?
Some conditions may be applied on me, my lord.
That's why you also go through. I will see that.
By the honorable court also.
The counsel for the petitioner has argued the matter at length. Both the parties have argued the matter at length. Let the matter appear on 20th August within 10 matters. File मेरे को भेज देना.
I have to research on it.
This is that aspect you come to that.
Yes.
Next.
কবে দিল দাদা এটা কত তারিখে 20
Yes.
I represent the respondent number 1, 2, 3, and 4, my lord. The mercantile.
My lord, I represent the.
I am for the respondent number 5. Jointly, we are making prayer. Item number 13. Would you also check up tomorrow because we have all preoccupied today. That's why I request you.
13.
13 tomorrow.
13 not today, Corey.
My lord, I will.
Yes.
Yes, my lord. First, I will consider the court facts, my lord, that the contract is still existing. The contract is still existing, though it has been terminated from their side, but the period is still existing, and the security deposit of the contract is with the
What is the
respondent number.
What is the prayer?
My lord, the prayer is to terminate, to squash the termination and the blacklisting, my lord, and the appointment of new workers, which I have told through a letter through a representative. 28 August 2005, which is annexed with the CAN.
Read in the nature of order cancel caused by the respondent number 325 when action concerned respective connection with gem contract. Where is the order, impugn order? P17 and 18.
Lordship, it is page 133 and 136.
P17.
P17 is at 133. My lord.
And my lord, then after they have sent the termination letter, my lord, which is annexed to the CAN.
EPF,
My lord,
delaying the wages underpaying EPF and supplying insufficient cleaning materials, staff unauthorized. Yes.
my lord, if check the CAN application, my lord, page number 11, presentation to change the workers also, my lord. That is also,
Can.
yes, my lord.
Where is the can? Can to আছে না? Yes. आप लोग कैन क्यों फाइल में नहीं डालते? Which page?
Page number 11, my lord. The representation made on 28/8/2025, my lord. Of worker, according to the terms of contract, my lord. My lord,
Number 11 is a prayer. Can 11, can 1.
can 1, my lord.
Page number 11 is a prayer.
Yes, my that's what I was.
The respondent also permit the petitioner to deploy new contractual manpower. The officer respondent has mentioned in letter.
Along with the termination of the squashing of the termination, has also been.
Yes.
Along with the squashing of the termination letter and the blacklisting, so this is also has been.
The contract is terminated, but remains.
Exactly. Yes, my lord.
What remains?
Yes, my lord.
So what you want?
My lord, the blacklisting first, my lord, the blacklisting and the termination.
Blacklisting time is over.
So, my lord, but we have noticed, my lord, that there will be continuing civil consequence because I have to place every member. I have to place that that I have been blacklisted previously, my lord, in every tender, my lord, because
So you're the habitual blacklister.
no, my lord. And if considered a hard and
Okay.
get the document.
What is your contention?
Yes, my lord.
Contention is that the blacklisting is not in accordance with law. So you want to marriage.
My lord, blacklisting on the termination, they haven't followed the procedure, my lord. The procedure is entirely wrong, my lord. It is arbitrary. My lord. That is what.
How you're claiming that is
My
not in
lord,
accordance with law?
Case of blacklisting, my lord, starting with the my lord. In case of blacklisting, my lord, they have definitely respondent number 5. In every proposition, my lord, and they have decided checked on merit education, my lord. How can this and accordingly they have
how this writ code can go into all the facts?
That's now, Lord. It is on the record itself, Lord. Consider record itself, my lord. Because, my lord, if you
What is the allegation? What is the allegation against you?
my lord, the allegation, that's what. The allegations are, my lord, substandard quality of service.
Correct.
Second, deficiency in legitimate quality. In the represent, and the material allegation of money from
Where is the so-called notice? Where is the so-called notice? That the allegation will be there.
My lord, Coco's notice is at page 97, my lord.
Huh? 97.
Lordship.
Page 97, my lord. My lord.
So-called notice. Delayed disbursement of payment to the laborers. Correct. This is the first one. Second is non-supply of cleaning materials. Then third is the non-compliance of the EPF. So EPF contribution, if you have not complied with whether any penalty has been imposed by the EPF authority.
Yes, my lord. My lord, no, my lord. No. My lord.
Section 17 and section 14 in proceeding was initiated.
My lord. Proceedings were initiated, my lord, and that penalty clause. They have a penalty clause.
Lordship, the contract may
They
be
have
has
a
been
penalty
agreed.
clause in item 51.
No, you come to the page 97.
Yes, my lord.
Come to the page 97. These are the 5 allegations again, 4 allegations.
Yes, my lord, but they have terminated on the basis of this letter, my lord, which they use the application, my lord, annexure 4.
Page.
My lord, page 1, my lord. With the termination letter.
Correct. So,
my lord, in these cases, my lord, there is a penalty clause in the contract itself. They have bypassed that clause and directly terminated us, my lord. That is not the procedure, that is the bad in law, my lord. That's what I have pleaded for this question of the termination letter along with the blacklisting, because in blacklisting, my lord, when they are up
that's why. So now you come to the reply to the so-called notice. You satisfied this is
my lord.
To the page 97.
Yes.
97, and what is the reply? Whether this reply was justifiable, but they have not considered. That is the only question.
Yes, my lord.
Correct.
Yes, my lord.
So it is not your case that the opportunity was not given.
Yes, I have so-called, my lord.
That's why come to the so-called 133. Where is the so-called reply?
99, my lord.
99.
Page 99 is the show cause.
You come to the so-called notice of 97, read with 99. So you cannot improve again other than this. Now come to the 97, the first, delayed in disbursement of the wages. Now kindly come to the 99 first. The only reason for delay in payment of our contract workers was non-receipt of the payment by us from the principal employer within the stipulated time. As the micro SME unit, we operate at a very tight cash flow, and though you are admitted.
Absolute admission.
My lord, I want to not promise the contractor who is contractor, my lord. Contractor is
Allegation you have not disputed the employee. Correct. As per the labor contract, you have to pay the he is having some financial difficulty, but you cannot retain the amount of the laborers.
But my lord, after this so-called
So-cause letter, that's the so-cause is allegation with regard to the delay payment.
My lord,
And you pay.
that's why,
Where is the contract? Where is the terms and condition of delay in payment?
yes, my lord. 54 and 61, my
The
lord.
clause
Those
is
number.
at page 54, my lord. And the clauses, my lord, 4.3.3 and 4.2.9.
Page 50.
Page
55, my lord.
54, my lord.
50.
My lord, 55 and 61. There is penalty clauses, my lord.
Yes, which condition, which clause you are relying upon? Page 54?
Yes.
Which
For
clause you are
any
relying
other breach and violation of the contract, 61, my lord.
Page 61.
Yes. Contravent of any terms and condition, my lord. Rupees 5,000 will be imposed per day, my lord. And 5%.
No, I am asking with regard to non-payment of the charges to the contract workers. Where is that? Is there any condition?
No, my lord. There is no particular condition related to that, my lord. After the notice, we have cleared all the dues, my lord.
That particular clause is at page 54, my lord. 54, clause 4.2.9, my lord. 4.2.9 at page 54.
The service provider contract shall not make any unauthorized deduction from the wages of the contractor labor and provide.
This is something different clause, my lord.
Yes, 4.9.2 second clause, see compensation, salary and manpower, employee resources engaged by it to be deployed by so. So you're not the
Material breach of contract.
That material breach of contract for the allegations of any kind of unethical. And other workers and I myself and market is
principal employee.
Respond 1 to 4, my lord.
So another condition, what is the other condition?
My lord, other conditions of cancellation is standard of quality material deficiency quality.
Non-supply of
Yes, my
cleaning
lord. For
material.
there is a penalty clause, my lord.
Non-supply of cleaning material, where is that clause?
Lordship,
If you
my
don't
lord,
supply.
My lord, we have supplied, my lord, first of all, my lord, there is
4.3.3, my lord. Kindly see at page 54, the same page, my lord. 4.3.3.
Deficiency of service or substandard quality of manpower deployed, breach of contract or change the requirement. Yes.
It is, my lord, 4.3.3.
Yes.
At page 54. Well, it starts at the agreement shall means with effect from the date of effectiveness of the agreement unless it is curtailed or terminated by the authority owing to deficiency of service, substandard quality of power deployed, manpower deployed, breach of contract.
my lord, but there is no termination, my lord. You can charge penalty, my lord. There is a clause with the
Let me
penalty.
see. Then non-compliance of API provision that will come, that is there. Yes. So, and unethical collection of money from the deployed stock.
That is, my lord, worker or with working with them, my lord. How can they adjudicate how can they come to the conclusion?
4.2.9.
Yes, my lord. There is my lord.
collection of money from the deployed.
No, my lord. That is.
Complaints have been received from the deployed personnel engaged by your company alleging that registered company
Yes, my lord.
collecting 400 to 4,000 per
It is
month.
only an allegation, my lord. It is not being decided by the authority. It is totally done by the I
Termination like 4.3.3.
and they have placed a new contract based on mobile.
Now you come to the page 134, your reply. Clause 4. The decision taken by the authority. Kindly come to 134.
Yes, my lord.
134 clause 4.
Yes,
Read
my
that.
lord. Regarding
Unethical collection of money from the deployed staff, Annexure 5. Owing to these irregularities, a meeting was held on so-and-so with the seller company represented so-and-so, and when the question was asked about this illegal taking charges of 4,000 rupees per month, the director answered that it is better principal employer not to inquire about this, as housekeeping staff are under the sole authority of service provider. And upon pressing the issue, they admitted that the money have been charging as registration fee of all conservation discussion were recorded and safely placed in the record. Then,
but my lord, that is part of their so-called, my lord. And yes, my lord. They have just put this record, my lord, from the recent, my lord.
after receipt of your reply, they have given this.
But they
reply. So
this is only a verbal
stated that how you can deny paragraph 4, 134.
And those who are employed as contractor, we received a complaint. They have
letter, my lord. That is their letter, my lord.
Nothing.
That is not my letter, my lord.
Nothing.
That is their letter, my lord.
Nothing.
This is their letter, my lord.
No, they are telling that.
That is responding. Worker and try to and for that, just putting this allegation, and just telling that I have admitted.
4,000
No,
rupees.
my lord, you haven't told, my lord.
How the authorities allow you to
That is
this is the service matter. You have to inquire, preliminary inquiry is to be conducted, charge sheet is to be issued, witness is to be examined. This is a contract.
If you
governed by the terms and conditions of the contract, the authorities on that, your violation of the contract, finish.
My lord, it is not part of allegation, my lord. It is not admitted by us, my lord.
So who will prove that it is not
My lord,
admitted?
you are government party. The contract of
focus notice was served.
No,
They
my lord,
didn't have-
we have denied, my lord. We have denied this allegation in our reply.
Right, but it is not your case that the no opportunity was given. Focus notice was given.
Yes, my lord.
You have given the reply, then they have considered that, subsequently passed an order. Correct. Now the termination plus along with your blacklisting, and blacklisting period is
over.
But blacklisting is over, but blacklisting. Blacklisting.
That's why this court has given
I know
the opportunity to satisfy that is the blacklisting is
it
not
is under
with law.
my lord,
See,
because
blacklisting is not in accordance with law. You have to sit. Blacklisting is not in accordance with law. There are three things. First thing, no opportunity. Third thing, the blacklisting is not in accordance with the terms and contracts.
Yes, my lord.
Correct. Third, the authorities have considered something else which is not under the contract.
Yes, my lord.
The things
My lord, the blacklisting, my lord, if you to the just gem management policy, my lord.
এর সাথে ফাইল করি, যেটা ফাইল করেছি আমরা ওর সাথে দিয়েছি। যে আমরা যে ওটা ফাইল করেছি তার ক্লজটা বলে দাও যে
Yes, gem management policy, what you want?
blacklisting is there, man.
My lord, gem management policy, my lord. There are four types of deviation, my lord. Mean deviation, serious deviation, severe deviation, and they have just they are telling the clear and platform, my lord, and they are having no merits. They haven't used the application of mind, my lord. They has put that on serious deviation, my lord. At the very instant of the complaint of the respondent number 4, my lord. That is what, my lord, the contention here, the blacklisting is bad in law, my lord.
You tell me, if you are not disbursing the wages of the employee, you are not supplying the cleaning materials, you are taking the unethical collection from the staffs. So this is
My lord, that is what I am telling, my lord, that the allegation of unethical collection, my lord, it is their part of allegation, my lord. And we completely denied that, my lord.
Denied that?
And we have denied by that.
They have stated that in the meeting, your director has admitted and he has stated that it is the principal.
My lord, they haven't got any reason from the director. If
you come to the page 134,
they would have asked, my lord, only letter from the director, they can show from the director of admission, my lord, of this contention, my lord. They have just of contention, my lord, which we even denied, my lord. My lord, we want the
yes, that's all. Anything further?
That is, my lord, I pray, my lord, that the termination blacklisting should be declared as valid in law, my lord. Let them decide again the matter further. And my lord, the security deposit, once they are going for termination, we don't want to discuss again. But that should be bad in law. That should be declared bad in law, my lord. That the court has the authority, my lord. Procedures, my lord.
Okay.
And my lord, they have jumped the deviation. They have bypassed the deviation. And under dictates, my lord, it is under the Supreme Court guideline, my lord, we cannot declare anything under the dictator, which is otherwise, my lord. That should be declared, my lord.
Okay.
I have the Supreme Court judgment and the government.
Who will decide?
The contractor, the market will
What is 135 and 130? What is the difference? What 135 is?
Lordship, 135. (133), 4 and 5,
Yes.
my lord, is by show cause notice.
No, it is not so cause notice. It is a proposal for
135 is, my lord, the decision of the buyer organization.
Yes.
No, this is
Yes.
decision, no decision.
Lordship,
Yes.
this is, my lord, the decision taken by me, my
Take
lord.
against the seller on the
This is the decision, my lord.
The page 133 to 135.
Ah.
And my lord, the blacklisting and termination, this is at page 136, which is by respondent number 5, my lord.
That is the incident raised.
Page 136, my lord. Kindly see just below the description section, incident responses. Now, GEM, that is respondent number 5, my lord. GEM admin took action on 29 July 2025, addressed to our Security Services your account has been suspended from 29th July 2025 to
That is
12th September.
incidence.
Lordship.
So where is the final order?
Lordship, this is the
What is
final
stated?
order, my
What
lord.
is stated?
Hey, the final order. It is this is
My lord, may I be allowed to note anything?
only respond to 5 to
JAM authority passed the order and
My lord, I'll show my lord. My lord, what is this? My lord, I may not be allowed to not explain the my lord policy. My lord, kindly have a look at the. I'll just want to explain that how it functions, my lord. My lord, kindly comes to page 5 of the policy that I have handed over to your lordship.
yes.
My lord, there are 3 situations. And one of the situation, my lord, already your lordship has dealt in that cartelization case. The action which was, my lord, solely, my lord, taken by the JAM authority. JAM authority, my lord, issued the show cause notice, and my lord, that my lord came to be challenged before your lordship. So that is, my lord, my lord, one instance. My lord, kindly sees under 2.2, there are 3 instances by which a buyer can be, my lord, debarred. Instance number 1, data-driven incidents. Incident identifiable through data available in JAM. In case of such incident, actions would be taken by the JAM admin based on data available with JAM. All incidents reasons not included in clause 2 and 3 below fall under the category. So, my lord, this is one instance where, my lord, JAM authority would, my lord, initiate the action for debarment and all. My lord, kindly comes to 2, which is, my lord, made applicable in respect of this case. Incidents not verifiable through data available in JAM. Incidents that require subjective decision based on information available with the buyer, seller, and consignee. In this case, my lord, buyer is the respondent number 1 to 4. Now, my lord, kindly see, for such incidents, buyer will have to first take internal approval of the competent authority on the issue under dispute and incident reasons. Then buyer will raise the incident on JAM and escalate it. Show cause notice shall be issued to the seller, which will be visible in the dashboard. And, my lord, show cause notice here we mean the show cause notice will be issued by the buyer department itself. We will, my lord, only show it in our portal. The reply of the seller received on the show cause notice will be first evaluated by the buyer organization. The buyer will submit seller's response to the competent authority in the buyer organization and take approval of the competent authority on the issue under dispute incident reasons. Decisions of buyer's competent authority on the issue will be uploaded by the buyer on JAM's IM dashboard and the dashboard in reply to the comments of the seller show cause notice. The uploaded document must clearly indicate the level of buyer competency authority, details of incident reason, the details of.
That's why after the show cause notice, the page 136, page 133 to 135 is the decision of the authority for taking and you are the competent authority. That is the 136.
Yes, my lord. So far as this 2 is concerned, my lord, here, my lord, we do not do anything. And under this 2 also, my lord, it is the buyer organization who has to defend this action. Here, my lord, we will not play any role. Now, my lord, kindly sees in 3. So far as 3 is concerned, kindly comes to the one next.
Yes, the detailed seller's reply.
Implementation of JAM buyer specific department suspension order issued by the respective organization, department, ministry, state, department, and expenditure. If the, my lord, banning order is under this clause, my lord, there, my lord, JAM authority will step in.
Correct.
Now, my lord, kindly sees the petitioner is saying that why it is serious. Now, serious deviation. Now, my lord, kindly see their show cause notice once. Kindly sees their show cause notice and along with not notice. Kindly come to page 97 once.
Yes.
Kindly see delays disbursement. There are 3 counts. There is delays disbursement of wages, non-supply of cleaning materials, and non-compliance of EPF contribution, unethical collection of money from the deposit staff. Now, kindly comes to the JAM's which was not visible on the portal. That is at page 136. How that clause 2.2 is applied. Now, my lord, kindly sees how this has been, my lord, performed in the JAM portal. Kindly sees the, my lord, description. Non-compliance of service level agreement. What is the incident, my lord? The buyer has raised? Non-compliance of the service level agreement. Unsatisfactory performance against the service contract. Value of contract is more than 10 lakhs. Delays disbursement of wages. Non-supply of cleaning materials. Non-compliance of EPF contribution. Unethical collection of money from deployed staff.
These are the clauses.
These are the, my lord, description. And, my lord, kindly comes to 137. From back, my lord. From the bottom, my lord, system added a comment on 23rd July 2025. Incident is due to incidents for due to escalation. If the mentioned deviation is resolved, please close the incident, or else if the issue is not resolved, please escalate the incident. Then, on the above, the service provider violated the key JAM contract laws by delaying wages, underlying EPF contribution, and supplying insufficient materials. Staff reported unauthorized 4,000 taking monthly. These breaches including 4.2, 8.9 and reflects serious non-compliance and may justify contract termination, blacklisting under JAM policies. Now, my lord, kindly see, then on the above, my lord, their show cause notice has come. Thereafter, my lord, their reply has come. And after, my lord, after their reply, my lord, by order dated 15 July 2025, my lord, the decision which was, my lord, taken by the authority concerned, my lord, passed that order asking us to take action. They have, my lord, they have, my lord, found that they were in breach and they were in guilty. Now, my lord, kindly sees.
So that's why 130 to 137 it is.
Yes.
So
So it is, my lord, their decision, my lord. We have, my lord, uploaded on the portal, and my lord, kindly sees why it is serious. Now, my lord, kindly.
Now I am first. So where is the final decision here?
Oh, here, yes. My lord, kindly sees that JAM. Now, incident response. That is at page 136.
Incident response.
So
you're given all the responses.
Yes, I have uploaded. My decision is, my lord, on the basis of their decision.
That's why now come to 137.
Yes.
Please find attached a reply of this so you have taken into consideration. It has been reported. So where is your decision?
Well,
you are required to acknowledge the same failing which you will not be allowed to do the activity. The same thing you are
yes,
reproduced.
Right.
Then what has happened?
No, my decision is, my lord, kindly comes to page 136. Now, what kindly see, your account your account has been suspended on 29 July to 2025.
Correct.
To 12/9/2025. The action is taken as per attached annexure 4 submitted by buyer in terms of clause 2.2 of the incident management policy of JAM for incident in question based on facts and details mentioned herein. Now, in under my lord 2.2, kindly sees, kindly my lord comes back to page 5 of the incident.
I am asking, see, he is also not taken that stand. 135, 133, 134, 135, they have stated that after receipt of their reply to the so-called notice, examined and this one decided to take action against the seller of the incident raised. 135 last paragraph. 135 last paragraph.
Yes.
I so and so designated chief surveyor come so and so have examined the seller's response and we have decided to take action against the seller on the incident raised. So it is the decision taken.
Yes.
Decided.
Yes.
Correct. So now where is that order?
No, my lord, that is what I am explaining.
So now you are telling that this has been because as per this your rules.
Yes, sir. Kindly comes to kindly comes to page 5 of my this incident policy. 1 second.
Yes, 5.
Yes.
Kindly come the 2II 2.2.II.
What kindly sees. For such incidents, buyer will have to first take internal approval of the competent authority on the issue under the dispute incident. The buyer will raise the incident on JAM and escalate it show cause notice shall be issued to the seller, which will be visible in their dashboard. My lord, show cause notice, which was my lord shown to your lordship, that was visible in the.
One by one.
Yes.
For such incident, buyer will have to take first internal approval of the competent authority issue under the dispute of incident. Then the buyer. So first they have to take a decision. Then the show cause notice is to be issued.
The show cause is finally issued, my lord.
Then the buyer will raise the incident to the GEM and escalate. Show cause notice shall be issued to the seller, which will be visible. So you have issued that. That's not dispute.
Well, I have not issued. It is
No,
in
that's why
the
it was showing by you in the dashboard.
dashboard.
Correct.
Correct.
Now come. The reply of the seller received on this SCN will be first evaluated by the buyer organization.
Right.
So they will evaluate. So they have evaluated, that is the 134 to 133 to
Correct.
135.
Correct, my lord.
Correct. By the said organization. The buyer will submit the seller's response to the competent authority, and the buyer will take approval of the competent authority on the issue under dispute incident reason. So where is that?
No, that is, my lord, not with us, my lord.
So
That they will show, my lord. That they will show. And I do not think, my lord, so far as the writ petition is concerned, competency of the authorities under check.
Not competency. See, this I appreciate show cause 97, reply 99.
Right.
They have taken the approval on 133 to 135.
Right.
Where is the final decision?
The final document, the final termination, which is at page 17, page 17 of the CAN by. Kindly see, my lord, which is
Page?
Annexure P2, page 17.
Page 17. I'm direct to refer the jump so from the record after the service has not been provided properly.
From the records, it is observed that the service has not been provided properly as per the GM contract. Regarding the same, on incident number this and this was also raised in GM as per gross irregularities in the service has been occurring. Hence, the competent authority has accorded approval for cancellation.
Correct. 29th August. Correct. So this is a cancellation. So where is the blacklisting? By which order the blacklisting?
But what I have been instructed by, on my part, there has been no final order of blacklist. Now, blacklisting for that period, my lord, whatever has been done by
Suspension.
is, my lord,
That termination, okay, that also not challenge. Termination, now you have come. That's why I am asking, because I am going through. You are referring that, but there is no conclusion with regard to termination and the blacklisting. And he has filed the writ petition and telling that my blacklisting. For the last 3 days, he made me a mind.
Only, my lord, suspension was done, my lord, on the basis of my lord incident raised, incidents, my lord. Only on the basis of that. That is why, my lord, kindly see.
Where is it? There's no so-called. That is no blacklisting.
Blacklisting, there is.
That is the suspension period, my lord. That is
there.
Suspension period.
No, your authority is there.
my lord.
Because why? If I will record, then you will be in trouble.
My lord. Here, my lord, I will like to consider, my lord, GEM policy, my lord.
You are not prepared.
My lord,
I have to do the
2D, my lord, 2D, my lord.
So far as now, kindly see, so have a look at this clause 2, my lord. I just want to.
What I wanted since beginning, I'm asking you, you're not thrown that. Now I have to search it out.
Okay.
Yes.
Now, kindly see on the last but 2 sentence, final action by the GEM admin.
Yes.
Will be taken only after uploading of competent authority decision on the GEM portal. That is the matter of decision.
Correct.
Buyer organization shall be.
So now the question. Now the can page 17 P2.
Yes.
Whether that has been uploaded by your GEM portal.
My lord,
P2. The competent authority decision. Because
This
the
termination.
uploaded document must be clearly indicate that now this competent
But
authority.
that is not cancellation one.
Cancellation.
But the cancellation, I am not concerned with the 132 to 135. That is not uploaded. Now, I want to kindly see, kindly comes to the next page, that is page 7.
Page
7, my lord. The incident.
Yes.
Kindly see.
Incident reason.
Incident reasons. Here, my lord, applicable 1, 2, and 7. Delaying, refusing payment of wages, salaries to the resources deployed at consignee location as per contract condition. Kindly see.
Yes.
That is not made out from the one of show cause notice and their final decision.
No, that's not that is not dispute.
Yes.
No, with regard to now they are admitting that there is no blacklisting.
There is no blacklisting, my lord. Only my lord suspension, my lord, which has my lord taken place. My lord, that
Suspension or not, they have cancelled. Treated as cancelled.
No, so far as JM is concerned, JM is my lord only.
Nothing to do.
Yes, my lord. That's all. That's all. But our action is only in terms of the policy.
In the principle.
Yes.
You are doing
that's
you are only the executing authority.
Right, my lord.
You are the executing authority.
Great, my lord.
My lord, in 2D, my lord, it is written, if the seller respond to this so-called notice, my lord, JM administration will review the discrepancy point out.
Where?
My lord, it is page 3, my lord, 2D.
Page 3?
2D.
Of the GEM?
Of the GEM policy. If the seller respond to the so-called notice, my lord, GEM admin will review the discrepancy, point out by the seller, and may correct the details to implement the debarment order as per details given on the debarment.
You are not been debarred.
Yes, my lord, it is not been debarred by the suspension, my lord. They haven't adjudicated the so-called notice, my lord. They even haven't considered.
Still you want, I will record that you have not been debarred, the blacklisted. Your tender has been cancelled. Cancel that these are the reason that is satisfied. So what further?
My lord, they have taken the contention, my lord, of the cancellation, that 4,000, my lord. That is not been admitted, my lord. And there is a penalty clause which they have, my lord. Let them all at least give them the security deposit, my lord. Refund the security deposit at least termination. They haven't. They have taken. They have not even returned the security deposit.
The clause D has been relied on. That is not coming under my lord 3. That is not separate case. That we have not done under clause 3.
Where is the work order?
The agreement starts at page 50, my lord, of the writ petition.
Oh, work order 65, my lord.
65. Before drafting the writ petition, go through the document, read properly, then draft it. Without the cause of action, you file the writ petition. Yes, recorded order. The petitioner has filed the present writ application being agreed and dissatisfied with the communication dated 25th of July 2025 and 29th of July 2025. The contention of the petitioner in the present writ application is that that on 30 December 2024, the respondent authorities have published a notice inviting tender for grant of contract for engaging nine numbers of sweepers within bracket unskilled with 1 numbers of supervisor for carrying out work with cleaning materials in the Mercantile Marine Department, Kolkata through GEM portal. The petitioner has participated in the said tender and he was the successful bidder, and on 4th of March 2025, the respondent authorities have issued the work order in favor of the petitioner. During the existence of the contract between the petitioner and the respondent authorities, on 15th of July 2025, the respondent authorities have issued a so-called notice to the petitioner on the allegation of delayed disbursement wages, non-supply of cleaning materials, non-compliance of in EPF contribution, and unethical collection of money from deployed staffs. On receipt of this so-called notice, the petitioner has submitted a reply to the said so-called notice on 18th of July 2026. On receipt of the so-called notice, the competent authority, after considering this reply to the reply of the petitioner, was of the view that have decided to take action against the petitioner on the said allegation against the petitioner. The same was also intimated to the GEM, and the GEM has placed the same in the GEM portal, in the dashboard of the GEM portal. Subsequently, on 29th of August 2025, the respondent authorities have taken a decision, the competent authorities have taken a decision for cancellation of the contract with effect from 1st of September 2025 by an order dated 29th of August 2025. The petitioner has filed the present application on two counts. One is with regard to illegal termination. Second, with regard to illegal blacklisting of the petitioner. It is at the time of hearing. The respondents have categorically submitted before this court on instruction that no blacklisting order has been passed against the petitioner. Thus, there is no question of going into further whether the blacklisting is correct and whether that there is no question of going into further to decide whether the blacklisting is correct or not. Thus, this court presumed that, and thus this court held that, as per the submission made by the respondent authorities, no blacklist, and the petitioner has not been declared as blacklisted. Okay. Now, with regard to the termination of the petitioner, the respondent authorities have in the so-called notice have categorically informed the petitioner with regard to the allegation of the delayed disbursement of wages, non-supply of cleaning materials, non-compliance of APF contribution, and unethical collection of the money from the deployed staff. The petitioner in the reply has stated with regard to the delay disbursement of wages that the delay in payment to the contract workers was due to non-receipt of the payments by the petitioner from the principal employer. And the petitioner being the MSME unit, micro MSME unit, and was suffering from severe financial hardship, due to which he could not make the payment to the contract workers. As regard the non-supply of the cleaning materials, the petitioner has given the reply that all materials supplied were fit for purpose was submit that the petitioner have supplied the adequate materials to the authorities in terms of the work order issued to the petitioner. As regard the contribution, as regard the non-compliance of the APF contributions, it is the case of the petitioner that the petitioner could not the monthly payment of the such members exceeds 15,000, the contribution payable by him in respect of the employer shall be limited to the amount payable on a monthly pay, that is a 15,000, including the dearness allowance. And as such, there is no delay in payment of EPF contribution. The allegation of the it is the allegation against the petitioner that the petitioner has forcefully collected rupees 4,000 per month from each of the employee under the guise of registration charges. But in reply to the said allegation, the petitioner stated that the allegation is totally false and they have not submitted, they have not received, and they have not collected any amount from the contract workers. By taking into consideration of the reply of the petitioner, the authorities have come to the conclusion. Authorities have come to the conclusion the reply filed by the petitioner is not satisfactory. It's not satisfactory. It is the authorities have come to the conclusion that the quantity and the quality has not, as per the material supplied by the petitioner is not as per the GEM contract, on the basis of which the supply order was issued to the petitioner. It is also taken into consideration by the authorities that with regard to the illegal charging of rupees 4,000 per month, the director, during the inquiry, the director had answered that it is better the principal employer, that is within bracket MMD Kolkata, not to inquire about this housekeeping staffs, as they are under the sole authority of the service provider. And upon pressing the issue, they have admitted that the money has been charging as registration fee. All conservation of the discussion were recorded and the safely placed in the records. Full stop. Considering all these things, the authorities have come to the conclusion that the petitioner the contract of the petitioner is liable to be terminated, and accordingly by an order dated by a communication dated 29th of August 2025, the contract has been cancelled. Considering the above, this court find that there are 4 allegations against the petitioner. The petitioner has given a proper opportunity of hearing. The petitioner has submitted the so-called reply. In the so-called reply, the petitioner only denying with regard to the charges leveled against the petitioner. But the authorities have considered the same and find that the allegation has the reply submitted by the petitioner is not satisfactory and the allegations are serious in nature. Accordingly, the authorities have taken the decision for cancellation of the tender. Thus, this court did not find any merit in the present writ application. Accordingly, writ application is dismissed.
Clarification, my lord. Only, my lord, one clarification, my lord. He was not blacklisted, but my lord, his account was suspended. His account was suspended.
ऊपर ना blacklisted, ऊपर एक जगह बोला ना not blacklisted, but his account was suspended, but the account of the petition was suspended. It made it clear that this court has only considered with regard to the order of termination, and this court has not gone into the further entitlement of the petitioner. The petitioner is at liberty to make appropriate prayer before the appropriate authority for his entitlement, and if any request is made by the petitioner for his entitlement, the authority will take decision in accordance with.
Oblige, my lord, oblige. Great. My lord, keep that policy, my lord, in the court.
I am keeping it.
Yes.
Every day it is coming.
Yes. Great, my lord.
Yes, call them.
My lord, I've got the petitioner. The appeal is on page number 67 ballot. This is a true applicant ballot. I've already deposited the court fees, requisite court fees, deposited court.
Two petitioners. How many petitioners?
Two petitioners.
Where is your appeal?
Appeal number, appeal.
Where is your appeal?
67 ballot.
Dispose of.
My lordship is disposed of matter 146.
Already disposed.
It is submitted that the appellate already disposed of. The appeal filed by the petition according to WP is dismissed as infractious. Yes, 40.
Well, I for the petitioner, well, praying for expeditious disposal of the appeal present in page number 38 of the writ petition.
Dispose of.
Much obliged.
148, page number 18 and 33, Lordship. Page number 18 and 33.
Disposed of. Both the brothers, sister, what?
Father, Lordship.
Next.
Paid the 149, page number 26, Lordship.
Disposed of.
Yes, my lord. Page 16, my lord.
Disposed of.
151, my lord, page number 65 and 70.
Disposed of.
Page number at 123.
Disposed of. Where is the deficit court fee? Pay. Disposed of.
Page number 28.
Disposed of.
My lord, in one way, I am for the petitioner appeal is page number 30.
Disposed of.
My lord, I am for the petitioner appeal is in page number 30.
Disposed of.
Page number 43, my lord.
Disposed of. No order. No order. Next. Next.
My lord, I am for the petitioner. I am for the petitioner, lordship, page 31.
Disposed of.
My lord, I am for the petitioner, my lord, four petitioners, brothers are.
Sure.
Brothers.
If I find, then I will not. I will dismiss.
My lord, I give the
Disposed
brother
of.
wife.
Where is the court fee?
Court fee is there. My lord, I have paid it.
Paid. Give the receipt. Disposed of. Next.
I am from the petitioner, petitioner prepared and appeal page 36.
Disposed of. Not required.
62, lordship, page number 36.
Disposed of.
163, page number 38.
Disposed of. Disposed of.
My lord, page number 37.
Disposed of.
Page number 30, my lord.
Disposed of.
There is a mistake in the name, Lordship, because the petitioner name has been deleted. His name was
So the appeal, and you can disposed of. Disposed of.
28, page number, my lord.
Disposed of.
16, my lord.
Disposed of. Disposed of.
Page 76.
Disposed of.
Lordship, 170, and for the petitioner, there is an urgency, Lordship.
What is urgency?
The petitioner has successfully qualified for the post of Constable, Lordship, West Bengal, and the interview has also been held. So, Lordship, any day the wait list will be published and the document verification will take place.
Record
There
and
was not been-
Look, document hai. Yesterday, two matters. I find that there's no document. I have not passed an order.
Lordship,
Where is the document?
Call letter interview is.
Where is the document?
Lordship, page 30.
The counsel for the petitioner submit that the petitioner is selected for the police constable and interview has also been completed. but and the merit list will be published shortly, and after the publication of the merit list, document verification will be done by the authority. She submit that the name of the petitioner has been deleted from the voter list, and the petitioner has already prepared an appeal before the appellate tribunal. She further submit that due to the deletion of the name of the petitioner from the voter list, the petitioner will not be in a position to submit the document before the authority at the time of verification of document. Accordingly, she pressed for expeditious disposal of the appeal pending before the appellate tribunal. In view of the above, the appellate tribunal is requested to dispose of the appeal filed by the petitioner as early as possible, preferably within a period of 2 weeks from the date of
Normal order. Lordship, item 1574, and for the petitioner, Lordship, the urgency is the Lordship, the passport has been withheld, the passport process has been withheld, Lordship.
Okay, you will get them automatically.
Lordship is
What is the necessity of the passport?
public for employment, Lordship, is
Employment. First you clear your disposed of.
Lordship, 175, the urgency is the government employee, Lordship, he is a police constable.
Is working and not been terminated.
Lordship, but already his document verification was done during the employment.
Correct.
Got the employment, Lordship.
Okay, no notice has been issued termination. Na? Okay, then okay, next.
Much.
And for the petition, Lordship, page 36.
Disposed of. Disposed of. Disposed of.
Page 16.
Disposed of.
Epic number.
Physical.
My lord, yeah.
Where is the epic number? The petitioner has filed the appeal in physical form. Being epic number WB/22/159/21634 Counsel for the petitioner press for expeditious disposal of the appeal by the appellate tribunal.
My lord, the petition is the cardiac patient, my lord. I am.
Submit that the petitioner is a cardiac patient and is not in a position to go to abroad for specialized treatment. And due to the deletion of the name of the petitioner from the voter list, the petitioner is not in a position to get the passport and the visa. He prayed for expeditious disposal of the appeal pending before the appellate authority. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to consider the appeal filed by the petitioner as early as possible, preferred within a period of 3 weeks from the date of receipt. Next.
My lord, item 180 and 181. The petitioners in those petitions are husband and wife. Their daughter, my lord, selected for the joint entrance examination, and my lord, due to non-issuance of domicile certificate, the petitioner daughter is suffering, my lord. My lord, there is.
So how these both are connected, 1 and 2, 81, 82?
80 is the wife, daughter's mother, and 81 is the father. My lord,
Mother and father filed separately?
Yes, my lord.
दोनों एक ही में order कर देना, with कर देना. The petitioners submit that the land council for the petitioners submit that the daughter of the petitioners has cleared the NEET examination.
No, my lord. West Bengal joint entrance examination, page 36.
Cleared
My
the
lord.
West Bengal joint entrance examination. But due to the deletion of the name of the mother and father from the voter list, the petitioner, the daughter of the petitioner is not getting the domicile certificate. Due to which the petitioner, daughter of the petitioner is facing difficulty to get the appointment. Accordingly, she submits that the petitioners have, being the mother and father, the petitioners have filed an appeal before the appellate authority, being agreed with the deletion of the name of the petitioners from the voter list, and the appeal is pending. She prays for an order upon the appellate tribunal for disposal of the appeal as early as possible. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to consider the appeal filed by the petitioners as early as possible, preferably within a period of 2 weeks from the date of reception.
Lord, Your Honor.
81 further.
Well, may I have your lordships kind leave to mention, my lord, I'm sorry for, my lord, at the cost of being reprimanded. My lord, your lordship had, my lord, directed this matter to appear within the first 10 matters, my lord, item number 62 of your lordship's list. And your lordship said that, my lord, if it is not taken up, my lord, then your lordship, my lord, mentioned the matter.
Yes.
Well, this is, Mr. Ray was there leading me in this matter. My lord, this is with regard to director identification number being disqualified of, my lord, the petitioner.
62.
62, my lord.
Okay, I will see.
Lord, under compelling circumstances, Lord.
I'm so grateful.
Lord, under compelling circumstances, seeking indulgence, Lord, to file.
Instead of
To file a matter with
your
lordship.
my lord, if your lordship, if it can be, my lord, if it
Okay, we'll see to that.
I'm so grateful to your lordship. So grateful.
Lord, my lord, I'm seeking indulgence, my lord, to file a matter with lordship's leave, my lord. My lord, I have been searched by one customs officers, my lord, and 108 notice has been served, my lord, without initiating any criminal process, my lord. They are raiding my house, my lord. Even the notice which has been served upon me, that does not have any particulars of what happens, my lord. My lord, kindly takes up, my lord.
Note कर लेना Monday कर देना. Yes.
My lord, well, by the revenue intelligence officer, I have been served by 108 Customs Act notice, my lord. Notice was served without the particulars against.
Why before this court?
My lord, no criminal action has been taken, but still, my lord, they are raiding my house. That is why, my lord.
So what you want?
Well, I am seeking, my lord, they set aside of that customs notice, my lord. That
Okay,
is,
so
my lord.
what is the urgency?
Agencies, my lord, they are raiding my house. I am.
Reading what that
Yes.
rate might be a
Apprehending one of
1 hour,
courtship action.
5 hours, 6 hours, 2 hours, whatever it may be.
I am apprehending one of courtship action because they have not
What courtship
initiated.
action? If the raid is conducted, if illegal things has been found.
No
after
criminal
the-
case has
after
been
the-
initiated against me.
The consequence has to be followed.
No, since no criminal case has not been initiated, that is why
That will
lordship's
be
court-
initiated after the raid.
Yes, but no, they have conducted, already they have conducted, they have collected some material, seized some material, but that does not contemplate any more criminal action.
How the raid court can decide all this?
Kindly takes up at any time.
Prayer you made.
No, I am praying for the
prayer?
setting aside of that order, and they will come up with better particulars, my lord.
Setting aside the order cannot be interim order, sir.
Customs Act, no, kindly
No,
takes
no.
up, my lord.
Yes.
Lordship, this was item 88 in your Lordship's list, kidney donors matter, no reasoned order has been passed. It's a case where the patient is getting critical from day to day. I was asking that we brought in within the first 10 matters, Lordship, item 88.
What is the prayer?
Lordship, for a reasoned order to be passed, I have faced interview, no order has been passed, whereas I have a person donor ready, he's the petitioner number 2, yet I'm not being allowed to.
Okay, we'll see.
My lord,
Lordship.
may I be permitted to mention one matter for correction? My lord, this is appearing as item number 143 on 10th of August, for your lordship's switch. But as the person appearing for the state, I have given my appearance, recorded my appearance, but someone else.
SIR matter?
SIR matter.
SIR, I am not correcting.
My lord, under compelling circumstances, my lord, may I seek leave to file a writ petition. My lord, my caste certificate has been cancelled unilaterally without complying with the provisions. My caste certificate has been cancelled unilaterally without the provisions of sub-rule 3, my lord, which provides that a show cause is to be given within a 15 days. And rule 4 provides for a personal hearing is to be given to me. Prior to that, a satisfaction has to be recorded, my lord, not has been done. And yesterday, my lord, it has been uploaded that my caste certificate is being cancelled, my lord. May I seek leave to move my urgency.
Urgency.
And my urgency is that I'm a student, my lord, presently pursuing the course of MBBS. My internal examination is from Monday. Now, my lord, if the caste certificate is cancelled, my lord, I will not be able to sit in the examination from Monday. And I'll just happy to my learned.
May I have a lordship's leave under very urgent circumstances?
Yes, call the list.
My lord, I beg to appear on behalf of the T-board, this matter, lordship.
This is my application, ma'am.
My lord, may I be permitted to file my affidavit in opposition? In
The direction was passed long back. They're serving it as.
Lordship, I'll be humbly beseeching you, Lordship. I have been engaged in this matter 3 days back, Lordship.
But may I cut short subject to my matter?
Yeah,
that matter which is now pending before Honorable
Supreme Court, my lord. So, my lord, I would humbly beseech, subject to what my learned senior friend says, that my lord, your lordship would kindly give us a time to deal with these affidavits, and my lord keeps the matter, my lord, after some time, we'll see what happens. Then, my lord, we'll come back and trouble your lordship.
So for item number 140, 141, 143.
My lord, I will be filing my affidavit.
I am appearing on 141, 143.
141, 143. And what about the 140?
In 140, I have filed my affidavit in opposition. In 142, Lordship, I also intend to file my affidavit in opposition, Lordship.
And
I am serving a copy to my esteemed senior.
And you filed, Achal.
Both of them.
Reply filed in the other matters.
The other lawyers. Set of lawyers.
You're not there.
They're
No,
not-
no,
they are
no,
not.
no.
140 and 142. 142. Counsel for the respondents filed affidavit in opposition after serving the copy to the London counsel for the petitioner. Counsel for the petitioner prays for time to file affidavit in reply. Let affidavit in reply be filed within 2 weeks. As regard the other matters, the pleadings are completed. In view of the above, case is adjourned.
My lord, possibly our replies are not filed in the other matters.
In the
Possibly. In case it's outstanding, well, we shall.
In other matters, the counsel for the petitioner prays for time to file affidavit in reply, if not filed. According case is adjourned. Prays for adjournment. Prays for time to file affidavit in reply, if not filed. Accordingly, evident reply be filed within 2 weeks. This is the matter. Yes, so
I am told that the affidavits have not been served in the other matters on us. I am told. But I am.
Yes, 141.
I don't think we should trouble your lordship with all these. Your lordship will kindly give us 3-4 weeks time because we have to deal with 4 affidavits. Kindly gives us 3 or 4 weeks time, Mula.
4 weeks.
In case it's
Reply
outside.
within 4 weeks.
Yes.
We have also been served the copy of the reply also.
After serving the copy.
No, 143. I'm talking about 140.
143.
143.
List the matter. List the matter in the combined monthly list of October 2026.
Grateful, my lord. I'm deeply grateful.
Combined monthly list. Yes, next.
I beg to appear on behalf of the petitioner, my lord.
Yes, who is for the state? Yes, what is the matter, sir?
My lord, matter,
The scheduled property,
matter
direction
relates.
of enforcement.
And my lord, I have a, my lord, at a three-story building. My lord, I have a agreement between the, my lord, private respondent number 6, my lord, for a period of 15 years. Lease agreement, my lord. But matter in the year 2020, my lord, in the year 2024, my lord, up to 24th February, the payment has been made. Thereafter, my lord, the respondent number 6, my lord, connected in various criminal cases. And my lord, he has been arrested. He took bail except one matter in Odisha case, my lord, money laundering case, my lord, he is in jail. But my problem is, my lord, the deed agreement, there is a clause, is 14 clause 3, my lord. In each consecutive month, he fails to pay the rent. The deed agreement, automatically it will be, my lord, cancelled. That is already, as per agreement, cancelled. But problem is, my lord, as he is in jail, and so many cases are criminal case pending. The respondent numbers, my lord, the ED of the officer of the Milord had read the house and seen the total building, three-story building. And my prayer is, Milord, I made the building upon loan from bank, Milord. My EMI has been stopped. Kindly direct the ED, Milord, to inspect the room. If whatever article is there, to remove and hand over the possession to me, Milord.
It is the possession of the tenant. How the ED will hand over the?
No, now has sealed the room, Lord.
You have to get the order from eviction of the private respondent. Then then the you getting on the only on the basis of the EDS sees that, then you come before this court.
Seals the building, Lord.
Maybe
Lord.
that is the property in question. Property of the.
I am the owner of the property, Lord. My EMI has been stopped, Lord.
You have given the property to the such person. What the ED will do, what the court will do?
Sees the building.
First you go and take the decree of the eviction of the private respondent.
Private respondent is not in position. How could I, my lord?
Why not? He is in custody. You serve the
agreement is already cancelled, Lord.
You go. How the writ court can decide with regard to?
As the ED has seen the entire building, Lord, kindly not direct the ED to inspect the room, inspect the room in my presence, Lord.
Who is appearing for the ED?
No, but I'm for the statement. Actually, statement copy even not served upon the state.
No, everybody have sub copies.
Oh, okay.
Every sub I have.
Maybe I will take.
And also I made twice into the ED all the time.
What the ED? I can call for the ED. ED will say it is the case property. So what the ED will do? How the ED will open the premises and hand it over to you, because the premises of the tenant.
The tenant.
You have to get the order of the eviction of the tenant from the competent court. The court cannot pass an order.
No, right now tenant is existing, Lord. Terms and conditions has already been expired, my lord. Terms and conditions has already been expired.
If it is correct, so whether the writ court can pass an order.
I direct the ED to inspect further inspection in my presence. What the articles is there, they may seize and I can take the possession. I am suffering, Lord.
Interfere on that.
No, kindly direct the ED to inspect inspection in my presence. Whatever I'll tell you, I am suffering.
Why in your presence inspection? The ED is conducting their own investigation.
No property, I am the owner of the property, Lord. That's why.
Property, no problem. You are the owner property. You go to the civil court and get the decree. But if they is not paying the rent and the agreement is over.
When petition is in jail, my lord, then who will handle the ED?
Officer has filed the present date application praying for a direction upon the respondent to unlock the scheduled property, which is sealed by the enforcement directorate on 22nd of May 2025 and for 2025. The private respondent is the tenant of the petitioner. The private respondent is indulged with several criminal activities. In one of the criminal cases against the private respondent, the enforcement directorate has seized the property He seized the tenanted premises of the private respondent, which is the property of the petitioner and petitioner here. The petitioners prays for a direction upon the enforcement directorate to open the lock and to inspect the premises in presence of the petitioner and to hand over the said premises to the petitioner. This court find that there is a relationship between the petitioner and the private respondent as landlord and tenant. The private respondent, the ED has seized the premises with regard to the criminal case initiated against the private respondent. The private respondent is at present in correctional home. And as such, this court did not find any merit in the present case, present writ application. According writ petition dismissed. However, dismissal of the writ petition will not prevent the petitioner for taking appropriate step before appropriate court of law for recovery of possession of the premises in question. Next.
Before the next matter is taken, I am told item number 143, which speaks was called on. I was looking at the board, my fault. I could not reach.
Yet, directions affidavit and October monthly list.
Not for earning fees, but only to face out.
You give the name. In which matter you give the
143 only.
You give the name. Give the name.
Sorry, I troubled.
And I'm paying for item number 175 already.
No. Yes, call the list.
Already hard.
14, I am appealing for the petitioner, Lordship.
175 point.
Lordship, this is a tender matter, Lordship.
Yes.
Lordship, petitioner number 5 voted a tender. As per the notification, petitioner participated in the tender proceeding. Thereafter, Lordship, one notice was published. The petitioner was declared the valid tenderer, valid bidder, Lordship, where his name was reflected in this. His name was reflected as serial number 6. Thereafter, all on a sudden, a cancellation notice was published by the authority concerned without assigning any reason.
Cancellation of tender notice.
Tender notice.
Yes.
What they have done, Lordship, there are 3 serial number was given in the first tender, and they clubbed together, and everything that has been high, Lordship, and the tender notice within the 10 days. They published the tender, face tender, Lordship. Immediately made a representation that has not yet been considered and disposed of. Lordship, my prayer before the Lordship, when the tender that has been cancelled, there assigned, the reason must be assigned there. That has not been done. Lordship, kindly come to the annexure P1, page 17.
Yes.
Where there
is for the respondent.
My lord, Mr. Shujo Mukherjee is appearing for the state, but he's running a high fever, which is why he could not make it today.
Which department the tender is?
The tender is the Superintendent Engineer, West Circle Municipal Engineering Directorate, Lordship, which is located at the Purva Bardhaman.
Yes.
Lordship, can you come to the annexure?
Yes, you are appearing for?
Mr. Shujo Mukherjee.
Which department?
For the state, my lord, at UDME, respondents 1 and 2, I believe. Yes, all.
Okay. So what is the submission?
Well, he's running a fever. He could not make it today.
Running a fever?
Yes.
Okay.
Also, last occasion they had already taken time. In this way, the work order will be issued and the petition will be.
Kindly see the last 3rd August. Mr. Mukherjee appeared. He has taken time. Today there is a fever.
Genuinely,
There is
genuinely has a high fever. He could not make it.
Body pain.
No, my lord. Genuinely, he has a high fever. Or else he would have. He had prepared for the case, but he could not make it today.
The petition will be infectious.
How soon he will recover from the fever?
My lord, next week.
Next week?
Yes, yes, my lord.
Viral?
I believe so.
Viral takes 1 week.
Uh,
Normal fever 2 days. Which fever he is having?
My lord, I'm not afraid.
Lordship, if Lordship will allow the time, then work order should not be issued by the authority concerned. That direction is to be given, Lordship. No problem. He is suffering from the fever. He will come back, and one direction is to be given.
What direction you want?
That is, the work order should not be issued by the authority concerned.
No, it is cancelled. How the work order will be?
No, the fresh tender that has been
tender issued.
Issued
when?
On Lordship, 12 June.
12 June. So
12 June, Lordship.
first
What
and-
they have done, we immediately come before the Honorable Court and file the writ petition.
Okay, come. As per the prayer made by the council for the state, the case is adjourned. Let the matter appear on 20th August within 10 minutes.
Direction is to be given, these authorities should not take any step.
Let me hear. Yes, next.
Policy,
No, my lord, please. My lord, the item number 175 already have done. But I have come late because I was not, I am from last night I am ill. That's why I came late, my lord. 175, my lord. My lord, please, my lord.
What?
Appearance.
আমি impanel.
26
कौन लिया?
कागज
अब कहाँ से उसका करेंगे?
175. এই, একটা কাগজ
P bolo, P bolo.
Yes, next.
Well, this is my application, Malad, writ petition. Malad, it is the affidavit of service. It is challenging, Malad, an inaction on the part of the Fire Services Authority, Malad. Malad, your Lordship is well aware, Calcutta is full of buildings, Malad, where there is problem with this fire thing, Malad, and there has been quite a few things going on. Malad, the writ petitioner, Malad, is the lessor, Malad, who has come into being the lessor from 2021. This is a G+9 building, Malad. Now, Malad, fire services requires, Malad, that there should be a certificate every 3 years. Now, Malad, we had applied for this certificate. And 2024, Malad, if your Lordship kindly comes to the document at page 40, Malad. Malad, kindly appreciate, say, Malad, I'll just point out the parties, Malad, your Lordship will kindly see. I am the petitioner.
I am the defendant in this eviction suit.
State is a performer. Is the state saying that? Malad, whatever it is, Malad, may I just continue, Malad? Malad, the point is, Malad, there is this, Malad, as he identifies himself that there's an eviction suit. This is the eviction suit. Malad, I don't want any eviction, Malad. Malad, there is.
So you are the owner.
I'm the lessor.
Lessor.
Malad, they were lessees of the earlier lessor. And their term has come to an end by a flux of time.
Of the lease.
Lease. Now, Malad, the crux before your Lordship is, Malad, we have a suit against them, that's a different thing altogether. I'm not going into that. They have filed writ petitions with the electricity and whatever it is. So, Malad, enforcement of tenancy rights, whatever they are doing. Here, Malad, kindly appreciates a building needs, Malad, fire, no objections. Or else I'll be, Malad, exposed.
Who are you?
I'm the lessor of the entire building. Owner and lessor. So, Malad, what has happened, Malad? I had asked, made a representation. The fire services, Malad, will kindly come to page 40. It will become clear, Malad. My learned friend's name is Vikas Motors Company. Malad, they are basically running a workshop.
Distributorship.
Workshop, distributorship, whatever it is, Malad, of scooters and two-wheelers. Now, Malad, when this was done, Malad, kindly let me place this letter. In reference to the subject noted above, an inspection was carried out at the aforementioned premises on 4th July in presence of such and such chairman of Orient Beverages. Malad, this Orient Beverages, the erstwhile lessor. And complainant is observed that one entrance exit gate along with some portions of driveway are blocked by the new motorcycles of the showroom. That's my learned friends. Malad, after this one, so it is requested to clear the blockade as early as possible. Now, Malad, this continues. Thereafter, Malad, kindly again comes to page 42. There is a similar request. Directions made by the divisional fire officer. Malad, now kindly comes to, Malad, page 48, Malad. Malad, the IT department is also there, Malad. That's the appellate authority, income tax appellate authority, Malad. Malad, it's a public building, Malad. There are people going there for public work, Malad. They have complained to the officer in charge. Malad, kindly sees officer of the income tax authorities, Malad, kindly, and dispute resolution has brought several intimations the notice of its current lessor McNeil Properties for free access to the office building from its main entrance from agency both roads, but nothing has been materialized. Now monsoon season has come and this office has experienced severe waterlogging in the ground floor of the building during the last monsoon seasons. Then Malad income tax authorities, Malad, they are talking about they have been posted and they are asking that the main entrance be cleared. Now this is something which they'll take up against me. But the only point which I'm trying to show from this document, Malad, that the entrance is being kept blocked. And the fire department has found my learned friend's client putting their things in the passage and it's completely blocked. Now, Malad, in 2026, Malad, kindly comes to Malad, page 62. This is the fire department writing to Vikas Motors, Malad, on 2nd September 2025. With reference to the above, you are again directed to comply the earlier letter issued by this office, dated 18 July 2024. And I've seen that, Malad. That's to Vikas again.
Yes.
Now, Vikas is the occupier who's doing this. There's no dispute about that.
Who is the Vikas, Mr. Chaudhary?
Yes, yes. So, Malad, thereafter, Malad will kindly come to P19, Malad. This is a letter of 29 January 2026, page 71, Malad. This is the fire safety recommendation for Malad, the safety certificate issued by the fire department this year. Now, Malad kindly comes page 74. Oh, Malad, there is under general recommendations the first.
So you got the fire certificate?
No, I cannot, Malad, because unless I comply with this.
What is recommended? The whole construction of
the driveway must be kept free all the time for ease access of fire appliances. No parking allowed in the driveway. Now
where from you are reading?
Malad, in page 74, Malad will find there is a general recommendation under a subheading O, Malad, from the bottom, if your lordship kindly sees, Malad.
74.
Page 74, Malad.
Yes.
Malad, I have complied with all of these. Now, Malad, as my learned friend is now saying, it's an eviction attempt. Malad, I don't understand, Malad. Let them, they are, Malad, kindly sees O1.
Yes.
This same tenor as the letters of 2024, they have not complied. Malad, eviction suit, Malad, they have a 2,500 showroom. Malad, I am not asking for any orders in that. I am only saying, please comply with the fire department. Now, Malad, if the fire department, they are not complying with it, Malad, fire department is under a compulsion, Malad, under the act, Malad, to take necessary steps. And I'm asking them to take steps, to give inspection and if required, remove it. But the fire access should be given so that I get this fire safety certificate also. Malad, now, as I said, Malad, they have come and now what are they saying before your lordship? I'm being evicted. Malad, it's not my job. But the fire department is under a compulsion to see that these hazards are removed. Malad, may I just show the rules and the act, Malad, if your lordship permits, Malad. Malad, may I also put it this way, Malad? Out of these, Malad, this has been given to me as the owner, lessor, Malad. I have taken steps, nearly 95% of my work is done. Only one work I've undertaken, Malad. It's just because the monsoon, Malad, they always require a second, Malad, metal staircase in a building. So, Malad, that is prepared, it's just going to be put up. After that, I don't have any other requirements, it's only this. So, unless I get this, Malad, I cannot also get the fire certificate. Now, Malad kindly comes and takes the.
Nah, I mean corporation.
Corporation is here. Now, Malad kindly take. Now, Malad,
but he's asking, Mr. Rai is asking me why I have come. But I am the non-answering respondent, so therefore most important.
He took away the mic from me, so I thought he's going to say something.
No, I am in the habit of taking away things from him for long.
No, he took it away so that what they were exchanging
He has
couldn't
come
go.
for the mediation.
Yes, yes. That is what he was saying to Mr. Rai, which is why he took the mic away.
Sorry.
Yes. Kindly comes to section 35, 34. Grateful.
But first is inspection of building premises. Well, this has been completed and recommendations have been given. Now, my lord, kindly see 35. The director of the superior nominated authority, as the case may be, shall, after completion of the inspection of the building or part thereof, or the premises referred to in section 34, record his or her its views on the deviation from or contravention of the requirements with regard to the fire prevention, fire safety measures, or the inadequacy or of non-compliance with such measures provided or to be provided therein with reference to the structure of the building or the premises or the nature of activities carried out in such building. Or part thereof premises and issue a notice to the owner or occupier of such building or part thereof a premises directing him to undertake such measures. Which wallet has been given to the occupier as well as me. Occupier is in possession according to him. And when such time is specified, when the owner is not available, occupier shall undertake such measures in the interest of public safety, not in anything contained in any other law for the time being in force. Now kindly comes to 36, my lord. Compliance with notice. The director may, in the event of non-compliance with any notice issued under 35, take such steps as may be necessary for the compliance with such notice. And the fire department therefore has the power, they are not taking any steps. And my lord, all expenses incurred by the director in relation to any steps taken by him shall be payable on demand by the owner or occupier on whom such notice is served and shall, if not paid within 30 days, then recovered. So it's the obligation of the fire department, my lord, to take care that there is fire safety regulations being maintained. And that is why this power has been given. I am saying I cannot, because my lord, the first thing when I say anything, they will come and say it's an eviction suit. Now, my lord, kindly comes to my lord, rule 19. My lord has the rules, my lord.
Yes.
Same book. Rule 19, page F49. My lord, But rule 19.
Yes.
Conditions for issue of fire safety certificate.
Yes.
Any high-risk building shall conform to any or all of the following conditions and of the conditions laid down in Part 4, National Building Code, Indian Standards and relevant building rules. As the licensed agency may deem explained with special reference to degree of hazard involved for obtaining a fire safety certificate. Now see, my lord. The building shall have the clear open space subject to provision of the relevant building rules or the relevant local authority in force. Now kindly see F. The building shall maintain any or all of the following minimum standards for fire prevention, fire safety as a licensed agency may deem expedient. That's ways of access.
Yes.
But the specific letters of the fire department thrice now say that there is no access. Access has been stopped. So I will not get the fire safety certificate. Not only that, it was hazardous to the entire building. The ITAT appellate forum is there. There are other lessees there, Now, one more thing, I'll just show. Kindly takes, because I believe, there has been earlier writs where they have been always saying that there is this tenancy and, kindly comes to section 42,
May I just,
Oh,
but may I just, my junior may I just come back in 5 minutes.
Yes.
When my junior is here, may I just come back in 5 minutes?
Yes.
Thank you.
Yes, yes, yes.
Kindly take section 42. This is my preemptive answer to one of Mr. Chaudhary's point that this is an eviction suit. That is one of my plans. After that, I don't know what he's going to say. I will reply later. But when it comes to this, act to have an overriding effect. The provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. Now sees, or in any instrument having effect by virtue of any law other than this act. And then, is subject to addition and that is. Now, I will just show one more complaint made by my learned friends in this court. Kindly sees. It just gives me a moment, yes. It kindly comes to page 79.
Yes.
Well, let's see the parties, my lord. This is the respondent coming to this court, my lord. Well, this is an electricity writ, my lord. They whatever orders they have got, well, that is under check. I'm not on that, my lord. Kindly comes to paragraph 5, my lord.
Paragraph
5.
Yes.
Where we had clearly said that fire safety norms are being broken by the petitioner, violated by the petitioner. And accordingly, my lord, we were also given the liberty to approach any other forum for this purpose. And that's why we have come before your lordship, my lord. Now, my lord, one judgment of this court, my lord, আমি দুটো কপি নিয়ে নিয়েছি
Yes.
Kindly sees. And here the petitioner was a trader in a congested area of Barbazar. Now, my lord, kindly sees. My lord, here this was an application asking the fire department to carry out an inspection and take necessary steps. But this is one step back. Here, my lord, inspection has been carried out. Finding has been reached by the fire department. Then kindly see page 2, my lord. Under section 34, empowers the director of the government to enter and inspect any building or a part of the premises at any time before sunrise. Under section 34(2), owner and occupier shall render all possible assistance. Well, I'm ready. Well, let's read it, my lord. So I'm not reading that, but my lord, 35, 36, 37, 37 AA. Then, my lord, sees it is clear from the above. 50 Act lays down procedure for inspection, secure, effective steps upon finding of such hazardous material inside the building. Is accordingly disposed of with the direction on the respondent number 2 to undertake an inspection and follow the procedure laid down. Well, that is what I am also asking you, your lordship. They have come to a finding. Well, the next paragraph, director shall be empowered to take all necessary steps hazardous inflammatory materials are found inside the concerned building with the subject matter of the writ petition as mandated, and the entire exercise to be completed within a fixed period. Now, these scooters, whatever they are or whatever they are placing, scooters or any other thing, well, they should not take that free access away, which is preventing me from their fire safety certificate. And that is why I've come up before your lordship. I've made them a party because I'm really not trying to hurt their any rights, if any. But this is my action against the fire department.
Okay.
That is my prayers are that let them make an inspection is done, let them take necessary steps and follow.
Who is for the fire department?
Well, I'm for the state ballot one.
Yes, state fire department. Yes. What is the instruction?
Not from the fire department, but so far as from the respondent number 8, my lord, the police authority, my lord.
It will not.
Fire department said that since there is basically a civil dispute, my lord. So,
and if the building gutted in fire, then what report you will say? Civil report, the non-necessity of the fire.
We will, my lord, we will take
And why? Since beginning, I am telling him before this court, I don't know what about the other courts. If the state means all department of the state, you can't say I am for the police department is only state. So you have to appear before for the fire authority also.
I made this submission when I was in office, and this is what I heard from your lordship. The left and the right hand are the same. That's what your lordship told me.
Since beginning.
Yes,
but we used to get instructions from all the departments and appear.
And here
I am finding it. No, my lord, I am not for the panchayat. No, my lord, I am for the
And
district
then,
magistrate. I am for the SDO. Even SDO and district magistrate separate.
I know.
Yes.
This will show your lordship what your very, very nice pictures, very nice building. This will show your lordship.
Who's the photographer?
Photographer,
Mr. Chaudhary or
we'll
Mr.
find out. We'll find out. Please see the top, shows the width of the road in front. Then, the bottom shows, that this is the one to the left is McNeil Court, which is the concerned building. So there is adequate space for a fire tender. that to go in. No, this is not agency.
I'm
bus.
talking about the agency bus.
This is the one. This is the main
agency bus.
This is the main entrance.
Now, take in that case, what I propose,
No,
I will direct the fire authority to submit the report.
Yes, no, Lord, may I? Just give me 2 minutes, then your lordship will decide. So this is the situation. Now, certain very important things, my lord, which your lordship must be told. Hey, other side ki copy now. My lord, this is where my tenancy was also permitted, my lord, the use of car parking. Right, Lord, for storage, my lord, really, of scooters. Correct. So then, my lord, I'll tell your lordship. Let me tell your lordship a little bit about the background of the matter.
Yes.
My lord, this is my tenancy is of 1985. And we, my lord, sell scooters and motorcycles. We have not Todi Honda. We sell scooters and motorcycles.
Honda.
Honda, my lord.
Todi Honda.
Todi Honda.
No,
That's the name.
But the company?
Honda.
Company is Honda. Distributors of Honda. Now, 1985, once we were inducted, subsequently 15-20 years, we had 2 car parking spaces. Then we requested them, and my lord, they permitted us to these new scooters which come, they are, my lord, parked at the back. This is my learned friend's problem. Now, when does he come in? He comes in recently. When he obtains, my lord, a concurrent lease in respect of the whole building. My previous lessor has given him a lease during the subsistence of my, my lord, tenancy. So that's going on in civil court. I say you have acquired no rights at all because concurrent leases are bad. Be that as it may, situation is that my existing tenancy from 1985, adjunct to the tenancy or appurtenant to the tenancy or part of the tenancy, is my right to, my lord, park these scooters. And I'm paying rent for that. Now I'm paying into, my lord, rent control. We've also shown that part as a part of, my lord, the tenancy. He, my lord, after he acquires title by this document of concurrent lease, he files an eviction suit against me. That is pending before the commercial court. We are contesting that. Secondly, my lord, he disconnects my electricity. So for that, my lord, we filed a writ petition and we were able to obtain an order of connection. And from that he is appealed, but he is not moved. He's kept that pending. Now he says, and he said this, my lord, at the hearing of my electricity writ petition, that he won't give me electricity because of the fact that I am, my lord, parking these vehicles here. This is an excuse for him. Now, my lord, please have a look at the very important document, which is at page 71.
You are applying a respond number?
8 and 9.
I'll tell your lordship, 10.
9 and 10.
9 and 10. My lord, after these recommendations, after these directions, superseding everything comes 29 January, page 71. 29 January 2026. This is the final recommendation.
Yes.
My lord, please see the second paragraph. The plan submitted by you was scrutinized and marked as found necessary from fire safety point of view. In returning one set of plan with recommendation, this office is issuing fire safety recommendation in favor of the aforesaid building for compliance of the following safety measures. A, my lord, is construction. That's, my lord, not relevant here. Then B, my lord, is open space. That is relevant here. My lord, please see B1. The open spaces surrounding the building shall conform to the relevant building rules. That is okay. And permit accessibility and maneuverability of fire appliances with turning facility. Now, my lord, kindly take the photograph, my lord.
Yes.
My lord, you can do, my lord, a fire tender, my lord, can go in, turn around, and there is no difficulty. There is enough space here. And I am told, my lord, by my learned friend, that income tax appellate tribunal is here in this building. A lot of cars are parked. It can go and come, my lord. There is no difficulty. On to the contrary, my lord, and I should tell this to your lordship, that passage at the back is only 10 feet wide. I have not seen a fire extinguisher, a fire tender, which can, my lord, maneuver itself into a 10 feet wide passage. It can never enter. I have a photograph to show your lordship. Your lordship will get a complete picture of what is the situation and how the scooters are parked. And then your lordship would, my lord, decide. This is, my lord. Of course. Arey, arekta copy daw. Lord, I'm sorry, but I have copies. I'll just give my learned friend. Yes. I've got lots of copies.
Glossy and very nice.
Milord, Milord, please see, Milord.
And red.
This is a 10 feet gate. No fire, Milord, tender can enter here. It's a 10 feet gate which is, Milord, kept open for persons to walk in and go out. Also, my lord, please see the overhang of the building. This was made 70, 80 years ago. My lord, the overhang of the building is such that it will, my lord, if you take something like a big truck or something, it won't pass through. So it's not a situation, 1 minute, it's not a situation that a fire tender can actually go through. Fire, because of the way the building is made, fire tender has to, my lord, turn around in the front entrance, which is completely, my lord, kept the other picture, my lord, photograph, which I handed up. Your lordship will see this. This is, my lord, the entrance. This is the inside area and this turning around. On the other hand, your lordship will find there is a temporary car park which has been made, which they have now made. Kindly see, my lord, this temporary car park over here. That takes up, my lord, a lot of the compound. So, my lord, it's not, my lord, that we are preventing fire or anything. So this is the final recommendation. My lord, this parking of scooters does not come in the way of being. Now, my lord, please see the rest. C, D, refuge area, water layout, sprinkler installation is on the next page, page 73. My lord, where, my lord, our scooters are kept, they have done sprinkler installations over there. We have never, my lord, created any disturbance. Your lordship will now see this picture. Lord, please see, my lord, this they have made everywhere. We have not stood in the way at all. Now, this is done by under, my lord, fire department. Then alarm system, multi-layer car parking, air conditioner, all of it is there. Then general recommendation, everything is there. So, my lord, it's not because of us. And all that they have to do is they have to act upon it and get it done because this complies. Only problem is this is a tool for them to secure an eviction from part of, my lord, my tenancy rights, for which a suit is pending. Nothing is preventing, my lord, the fire department from giving them a license, accepting them. They just want to create problems and, my lord, prejudice us. That is the objective. And please see now the press. Your lordship, once your lordship sees the press, the motive will be clear. Please come to page 28. Mandamus, long press, my lord. Mandamus for removal of obstruction blockade And you're describing it as main entrance, that's not false. I wouldn't have done it. Then will not be. Again, will not obstruction of main entrance. This is not main entrance. Then C. Police assistant. So objective is not to get Millard fire license. That's been given. Objective is to, no, that recommendation is there. All you have to do is ask for inspection, get it. But they don't do that. Their intention, more than getting fire, Millard recommendations carried out, is to, Millard, is to remove my scooters. That they've tried in the earlier, they're trying now. Prayers are, Millard, please see the prayers. They want fire to physically clear out the passage. Millard, please see the prayers. This is not a statutory duty of fire to clear out passages. They will give recommendation. And if I stand in, in between recommendations being enforced, they will take action.
Showing it as a main entrance.
Now they are, falsely showing that other passage as the main entrance, and they are trying to, motive of the writ petition, praise in the writ petition is to, clear out the scooters.
Yes.
I leave it to your, fire is not a sensitive issue. I leave it to your lordship. We are not standing in the way of anything. Whatever your lordship feels, for public safety, we are not standing in the way. But please, see the motive, and your lordship, whatever your lordship tells us to do, we will of course do.
Yes.
But please protect our tenancy, Millard.
Let me just reply very quickly. But he has raised an issue about which is the main entrance. But he has given a document, Millard. But your lordship will see it is the AJC post route. The main entrance is from the AJC post route. So where have I gone wrong? Rather, this picture, Millard, your lordship can send anyone. This is not 10 feet. It's more than 10 feet. So, Millard, these things which are being told, Millard, obviously to preempt this court from looking into, Millard, I would rather beseech your lordship, Millard, kindly appreciates two things. This is a piece of paper. Millard, they have not brought before your lordship the document on which the tenancy was given. They have not got it before your lordship. Second, Millard, let us not make.
Against whom the suit is pending?
Them.
Against us. Who was filed? You have filed.
Yes.
Millard, let us forget the civil suit part.
Millard, this is the tenancy agreement.
Yes, let us see it.
You have a copy because it was a part of.
You can find that this is there, Millard. Your lordship will kindly allow it. Millard, whether there is anything mentioned about this, whatever they are saying, Millard, this has been completed.
Millard, it was extended.
How can it be extended like
Of
this?
course it can be.
Without any instrument.
So that is now the objective is clear.
So now the objective is.
That, Millard.
Of
Millard,
course, you have
there is the
only.
fire department. Let them take an inspection. Whatever they need to do, I can, Millard, with regard to this access, I cannot do anything. Rest I can do. If they feel that they can give me a fire safety certificate, I'll take it. I don't have a problem.
Okay.
They should not prevent me from this. Millard, because their scooters are being lined up, because Millard kindly finds from 24, and that is what I've asked for. They have been writing to them, not to me.
Okay.
So, Millard, if your lordship sends the fire department, let them file a report.
Millard, I can also file an affidavit putting all the facts on record.
Yes, Millard, that is what the.
No, what I propose, I will record your submission. I will direct the fire authority to submit the report with regard, because as per this letter, whether the space is required for giving the fire safety certificate or not, then they file the report. If they know, unless and until it's not required, then you file the exception to them. And the
Yes, and if it is required, they are saying required, then required. I'm not into a civil suit.
If the fire authority said then this motorcycle is to be removed for giving the fire certificate, then you will get the opportunity to file the exception to the report. Then you file the exception, then the court will
Very
decide whether it is required or
Very well, no difficulty, Millard.
The point of integrity was this.
Yes.
And maintainability kept open, Millard.
Huh?
Then I'll argue, Millard, that it's not maintainable also.
And Millard,
The
also,
objective is something else.
Already been decided in another writ petition.
Right.
These were the issues also taken there. It was for electricity connection, but these issues were also taken.
That's the electricity connection.
Show me.
Millard, that's the judgment which I showed.
You know, can I take a page 8?
Yes.
Page 8, paragraph 5.
Yes. Civil dispute. That is with regard.
Kindly see the last line. The private is also alleged infraction of municipal and fire safety law.
Yes.
So these were already decided.
You are appearing for whom? Fire.
State.
Then you can. Then I have to put the sub question to you. Kindly come to the page 40. If you are relying upon that, you come to the page 40. Herein now I will decide the writ petition.
No, that will prejudice me.
Because the fire authority is taking the other stand, and now come to the page 40. If you are taking that stand, whether you can take stand contrary to the department. Kindly come to the page 40, sir. Read the page 40.
Complaint regarding illegal blockage of passage from main gate on
Who has issued this letter?
West Bengal Fire Emergency.
Then you kindly come to the page 58. Please go through the document, then make submission before the court. You are appearing for the authority, I know, but you see what your authority has done, and whether you have because your the colleague was there. Kindly see page 48. Read the page 48.
Request for removal of unauthorized this from Ministry of Income Tax. Request for removal of unauthorized blockage to main entrance of court. Office of the Income Tax Supply, Ministry of Law and Justice on India's House at 6 and 7 floor of LP court building, etc. Income Tax Supply Tribunal and Dispute Resolution Forum.
Yes. Then you come to the page 62. Page 62.
To the divisional manager with reference to your main again director comply with the earlier letters issued by the office.
18 July. Now 18 July is page 40. Then please go through the document. Your authority is telling that comply with that. You are telling that not already decided. If it already decided, why the authority is writing all these things? You tell if you say I will record your submission. Yes, the authority has given the certificate is required. What the court has given the opinion, you are not heard. Your colleague knows what the court is going to pass an order. The main grievance of the petitioner in the present application that the West Bengal Fire and Emergency Services Authority have inspected the premises of the petition premises in question for grant of fire certificate, wherein and on inspection of the said premises, it was found that there was blockade by the new motorcycles by the showroom of Vikas Motors Company. Accordingly requested the general manager Vikas Motor Company to clear the blockade as early as possible from the fire and life safety point of view. Subsequently, again the subsequently the Income Tax Appellate Tribunal has also requested the Fire Services Authority for removal of unauthorized blockage to the main entrance of the LEP Court building situated at 225C AGC Road. Thereafter, on 2nd of September 2025, the fire authorities has requested the Vikas Motors to comply with the earlier direction of letter earlier directions issued by letter number 18th of July 2024. 2024. The petitioner has relied upon the recommendation of the Fire Service Authorities issued on 29th of January 2026, wherein in clause O within bracket 1, it is recorded that driveway must be kept free all the time for least access of fire appliances. No parking are allowed in the driveway. Land Council for the petitioner submit that in spite of several directions issued by the West Bengal Fire Service and Emergency Services, till date that has not been complied with, and fire service certificate has not been issued to the petitioner. He prayed for a direction upon the fire service authorities to take appropriate steps in compliance of the letter dated 18 July 2024 for removal of the blockade and to issue fire service certificate. Land Council appearing for the private respondent number 8 and 9. 8, 9 or 9, 10?
9, 10, Malad.
9 and 10.
Sorry, I should have said
9 and 10 submits that there is a civil dispute between the petitioner and the private respondent. The petitioner intending to evict the petitioner from the said premises illegally by taking the recourse of the fire service authorities. He has relied upon a letter dated 17 June 2006 issued by Orient Beverages Private Limited, wherein who is the earlier owner or lessee?
Earlier lessor had given the money.
Earlier lessor who has given the premises in question to the private respondent, and in the said communication, it was mentioned that the private respondents were allowed to park the scooters instead of cars at the eastern side of the open space, labeling 2 parking space allotted to MSTC Limited towards southeastern side. There will be free access to and from AGC Bose Road to southern side of the premises, and you will not block the space meant for other occupants. He further submits that he has also relied upon the photographs. And submits that the space between the 2 buildings are only 10 feet, and no fire tender can enter into the from the said space. He further relied upon the other documents which further photographs, and submits that from the said photograph it is categorically clear that the 1 fire tender can go inside and return back from the said space, and as such there is no necessity of removal of the parking of the motorcycle of the private respondent. Land Council appearing for the state authorities has submit that the respondent authorities have already issued the notice to the private respondents, but it has not been complied with. Consider the submission made by the council for the parties. This court find that before passing any order, a report is required to be filed by the West Bengal Fire and Emergency Services before this court to indicating that whether the parking of the motorcycles by the private respondents, namely Vikas Motor Company, is required to be cleared for grant of the fire service to the petitioner, and whether till today the parking of the motorcycle is available in the space in terms of the notice date, in terms of the letter dated 18th of July 2024. The fire authorities are directed to inspect the premises within a week from date and to submit the report before this court whether the blockade of the blockade of the area by parking of the motorcycle is still there or not, or whether by parking the motorcycle over the said area, whether the authority can provide the prior certificate to the petitioner.
Fire safety certificate.
Fire safety certificate.
They are very technical now, my lord.
Fire safety
Very
certificate.
conscious now.
Let the report be filed within 2 weeks by on or before on or before 27th of August 2026. Let the matter appear on 27th August under the same heading within 10 matters.
Very grateful, madam. Very good.
Open na affidavit of service he kept with the report. वो दे दो वापस दे दो कोई. Next 3 p.m. original side.
The original side of it.
Yes. Come tomorrow.
1 minute matter.
उसको दे लेके जाओ लेके आना.
My lord, may I read the last order? Oh, mentioning, I'm sorry. Sorry.
Or mentioning?
No, my lord. Item number 1, my lord.
Yes.
My lord, Mr. Ghosh is here.
Report filed.
My lord, it is
Monday.
Everything by Monday.
The special or referee or special officer? Special
referee.
Special referee. That's
Special referee.
special.
Submit that. Report is ready. He will file within a week. According cases adjourned. Let the matter appear on 21st August.
Just like finally want to see whether
Or 25th of August for filing report by the
25th
special under the same.
That's a Monday.
25th of August under the same heading for filing report by.
25th.
Next. কি আছে?
This matter, my lord, I appear for the petitioner. My lord, we are enjoying an interim order. My lord, it is still today. So they had filed a vacating application which was to be treated as an opposition, and we
Yes,
had
yes,
to
yes.
file a reply. My lord, we are filing a reply. My lord,
Next week, any
Well, I really cannot oppose because I am personally aware of the situation.
My lord,
And-
I had indicated also in the morning.
Yes,
No problem. You take your rest.
2 weeks, any day. Any day, Lordship will, because I am personally aware of.
What you filed reply?
Yes, we filed a reply, my lord. Lordship will extend
Petitioner
it
has
and
filed
keep it
reply.
any day convenient to them, my lord.
Then be kept with the record. Counsel for the petition submitted the interim order is still today and paid for extension of interim order. And then counsel for the respondent number 2 raised for time due to some personal difficulties. Accordingly, case is adjourned. Let the matter appear on.
My lord, I leave it to your lordship after 1 week any day. I don't have any problem.
23rd. 21-22 থাকবো, তাহলে 23rd, হ্যাঁ 23rd এ করে 21-22
23rd September. 23rd September at 3:45 p.m. Interim order is extended till the next date of the hearing.
Grateful to lordship.
Yes.
That is my.
Who is for the petitioner?
Respondents, my lord. We have raised one preliminary issue with regard to my lord.
Who is the petitioner?
Territorial jurisdiction.
Huh?
With regard to territorial jurisdiction, the preliminary issue has been raised. Mr. Shakushan was on the other day arguing this matter. He was on behalf of.
Territorial jurisdiction you are raised.
Yes. My lord, may permitted to.
Nobody is here. Not today. Next.
The list has collapsed, my lord.
Yeah, yesterday is Arvind, now today is not here. Sebi is also not here. He has to argue. Not today.
Your Lordship, Aritra Basu is appearing for the writ petitioner. Kindly grants a short passover.
Yes, where is Mr. Basu? Who is for the other side? Matter list ही मत करो. Not today. सब hearing में है, सब hearing में कोई नहीं. Not today.
Plus item 9. Plus item 9. This is my petition minutes. Plus I appear for the petitioner.
Yes.
Item 9.
Yes.
Because this is the matter, if Milos may recall, Milos, the issue was with respect to the payment of OTS. The parties have entered into the OTS settlement, upon which we have deposited the 10% of OTS amount. And there was a promise made by the State Bank of India that if at all the OTS fails, we will be refunded back the OTS amount, the 10% OTS amount. However, Milods, that 10% has not been refunded. Milods, in between, Milods, what has happened is the
Which side? Which bank?
State Bank of India, Milods.
Nobody is here. Not today.
Milods, if affidavits can be directed, if at all possible, Milods.
Other side is not here. Who is for the petitioner? Jayanto Narayan Chatterjee. Now, petitioner is not there, how you will communicate? Petitioner is not interested. None appears on behalf of the petitioner, so and so appearing for the estate. None appears on behalf of the petitioner, so and so appearing for the estate. No accommodation is sought for the interest of justice. Case is adjourned. Let the matter appear on 14th September. Next.
Milord, item number 11, I am appearing on behalf of Milord, the writ petitioner. It's a very interesting case, Milord. I have a valid passport in my favor.
Good.
Milord, the passport expired.
Good.
I applied for the passport. Too many times I see that a person has visited Vietnam and Thailand. there is a criminal case pending against him. Now, the criminal case which is pending against him, Milord, was not taken into consideration when the passport was issued, when the passport was renewed, because it had to be renewed. Since Milord, I applied after it was expired, I had to apply online. It was checked, verified, and it was, Milord, renewed. After renewal, Milord, I receive a show cause notice. So it's a case of section 10. After I receive a show cause notice, I write them a representation that if at all you could have raised a dispute when I had applied for renewal, but you have considered my renewal application, you have passed the test for me, and I have received a renewal passport. Now you raise a show cause and refrain me from any future or further travel. This is, Milord, the sum and substance of my application. Your Lordship, Milord, has...
What is the case against you?
Milord, it's a...
What is the action?
I have to check that, Milord. I have to check that, but I must, Milord, call upon my learned colleague. The case is, Milord, not with respect to money laundering, etc., which is basically with
No, that's why
court see look into.
That's why
Yes.
if it is a petty matters, is a summons trial,
then it will not be of such importance.
case, and there is no requirement.
I have written a representation also.
Latest, my latest judgment is there.
The Lordship's latest judgment is there, and Milord, I'm not carrying your Lordship's judgment, but there is a 2025 Supreme Court also on it, which came up in live
Mahesh
law.
Agarwal.
Yes, Mahesh Agarwal.
Mahesh Agarwal.
Yes, yes.
That's why it is.
Mahesh Kumar Agarwal, your Lordship has in fact followed Mahesh Kumar Agarwal.
Followed the Mahesh Agarwal, and all this, and then this
Yes.
court has stated that if the court has given the no objection and the court has put the conditions with regard to, then he can issue the passport.
My lord.
For the unlimited
Yes.
period, as per the rule of 10 years.
Yes, my lord.
Correct. And if and it is upon the court, if the court has granted permission, then you cannot. So if they have granted, the passport, let us see.
Kindly have a look at page 49, my lord. The sections are also mentioned.
Page 49.
49. This is, my lord, the impugned direction which I am challenging in this writ petition.
Under section 27A, 28A, and 23, what?
Well, that I don't know, my lord.
What 28? What?
I don't know, my lord. On this ground itself, it is, my
Which
lord.
provision?
I'm not aware, my lord. In fact, my client is also not fully aware of what they wanted to say and mean. I'm sure, my lord, the learned senior adversary will not stand in
Guest
the way of-
appearance.
No, not guest appearance. It's a very much well-informed appearance. We will kindly see Mahesh Agarwal is, my lord, very clear. This cannot be a case, my lord, where my travel can be restrained. Yes, my lord, kindly, my lord. So, my lord, can I show your lordship first? Kindly, my lord, come to page 10. 10, my lord. Page 10, my lord, is the passport which I originally had. Page 10.
Yes.
Now, my lord, we'll have a look at, my lord, page 28, which is, my lord, and my lord, I have a heavy passport. Your lordship will see, my lord, that the person concerned, the petitioner, has travelled avidly to several places and countries. Now, my lord, we'll have a look at page 28. This is, my lord, my online application receipt. And whatever are the disclosures, your lordship knows, my lord, these are forms. I will have to disclose. I made disclosures, and based on this, my lord, at page 31, the approved renewed passport is issued in my favor. At page 31. This, your lordship, my lord, will see kindly the page 31 itself, the two dates. Date of issue 1st July 2026 and date of expiry 30th June 2035. So this is, my lord, the renewed passport. Till this stage, that is till 1st of July 2026, there is no whisper regarding any objection which the authority may have against me for any criminal case which is pending. I am certainly not a convict. Now, my lord, will kindly have the next document which I immediately received. That is the document which I had shown your lordship at the very inception, page 49. which is, my lord, under challenge in this writ petition. May I place it, my lord? Clarification required regarding issuance of passport facilities to Shri Rajaram Ghoshal. Kindly have a look at this, my lord, judgment of Ardao. September 25, 2025. This is happening well after, my lord, almost 2 months. Please refer to your above file number in which passport has been issued as per extant rules subject to police verification. Now police report has been received as adverse with observation that criminal proceedings, the IPP applicant is involved in Arambagh PS case number such and such under section 27A, 28A, 22 bracket 3. Now I do not know what are these provisions, my lord. I have asked my client is unable to say. The case is sub judice, is pending in a court in India against your name. You are hereby asked to show cause as to why your passport should not be impounded, revoked under section 10(3)E. This is a clear case of 10(3)E, is not a case of section 6. So, my lord, if it is not a case of section 6, my lord, then I am already through because I have a valid renewed passport in my favor. Now, my lord, the fact that this particular notice itself is incomplete, it doesn't say which cases are pending against me, under which provision of law is a good enough reason for this incomplete representation or incomplete direction or order to be quashed. This is my first point before your lordship. Because your lordship is completely aware, my lord, if there is a criminal case pending, a person may know about it, may not know about it. Cognizable and non-cognizable, this is the maximum I could master. Cognizable or non-cognizable, police will inform you about it, try to arrest you, or in other cases, police may not take any steps. So I may come to know, I may not come to know. I do come to know, my lord, about this when I receive this letter. I am precisely not aware of what provision, what, my lord, under which law this has been attracted against. So, my lord, consequently, my lord, kindly come to the next page, page 50. I give a representation to them. And in the representation, my lord, I say, now it is well settled principle of law that mere pendency of criminal case cannot deprive the citizens of India to have benefits of passport. See the following judgment, and my lord, I refer to several judgments passed by, my lord, the several courts.
Have you referred the 1993 notification? Have you referred this?
No, 1993 notification not referred, which is a part of Mahesh Kumar's. That is the main case. So, my lord, I am not. Lordship wants me to cite Mahesh Kumar, I can, but your lordship's order is also there. This is, my lord, the open and shut case. Rest time, my lord, I shall respond to after what Mr. Tiwari, my lord, senior says. If there is any, my lord, reason to lock me up and not allow me to move, because may I make this, just read it out for your lordship, my lord. Paragraph 2 of Mahesh Agarwal's judgment. Liberty in our constitutional scheme is not a gift of the state, but its first obligation. The freedom of a citizen to move, to travel, to pursue livelihood and opportunity subject to law is an essential part of the guarantee under Article 21 of the Constitution. The state may, where statute so provides, regulate or restrain that freedom in the interest of justice, secure or public order, but such restraint must be narrowly confined to what is necessary, proportionate to the object sought to be achieved, and clearly anchored in law. When procedural safeguards are converted into rigid barriers or temporary disabilities are allowed to harden its indefinite exclusions, the balance between the power of the state and the dignity of the individual is disturbed, and the promise of the Constitution is put at risk.
Yes, Mr. Trivedi.
The best part is, our instructions are there, we supply a copy.
Thank
you. I am arguing this one, being on this side. But everybody knows their fundamental right. Nobody thinks of their fundamental duty. Now, my lord, the preface of my argument. Tatkal passport, my lord knows better than me. Sitting in jail, I am just a new entrant after doing this. This is pre-police verification. So I go by virtue of whatever you state on. One of the parameters is that you have to affirm that I have no criminal cases pending against me. And you get a Tatkal pass. Subsequently, when police verification is done and it comes to my.
It is Tatkal?
Yeah.
The Tatkal certificate? Who has given the certificate?
I'm coming to that. Madam will not, otherwise. Madam, kindly. I will show, sir. There is nothing on our part. Now, Tatkal, therefore I said to the prefix. Tatkal, a person applied, he has given a certificate that I have no criminal case pending. Now, Lordship, what happened is we issue passport subject to outcome police report. When outcome of police report comes, we give him a notice. Under what we give him a show cause that many times what happens, my lords, that since there are a series of judgments, sometimes maybe the police will say there is some stay or so we gave him a show cause. Show cause what we said specifically what rules and what act. Act section 10 we said and rules he may not know those rules or our internal, but he knows that he is arraigned in a criminal case. Now, the second point is that we have not received a show cause till date, which he is championing for, that I have given a show cause. I have given a reply to the show cause. Now, Lordship will kindly come and see his show cause, how he has served on us. I have get information from my that. My Lord will kindly come to page 50.
Yes, I am there on.
My Lord will come. Now, my Lord will kindly come to the portion how he is affirmed. How did he serve it on me? We have to say that. Paragraph 9, if my Lord kindly takes up. He has said everything under the sun. But how it was served on me, he has not said. Lordship will kindly see. Thus, on 6th November 2025, your petitioner filed a detailed representation with the respondent authority containing so and so. All right. Very nice. Now, Lordship will kindly come. A copy of the representation. I am asking my learned friend to show a postal receipt.
Okay, see.
Now, Lordship,
so what is the case against him?
The case against him is, Lordship, that he himself now coming to, once again, my Lord, my Lord, kindly come to page 50. His representation. Yes. He is saying that this is he himself is admitting. In second, Malad will kindly come to page 50. Lordship will kindly see the first paragraph.
Cosmetic.
Subparagraph 1.
Drugs and cosmetic.
A false and motivated case. So he knew it. This is a case of 2020. When did he apply for the passport? Lordship will kindly come to E2, page 28. June 2025. Now, will Mahesh Agarwal or any case under the sun will come to his rescue, because the person who comes to the Honorable Writ Court and perpetrated fraud and is suppressing material facts is not entitled to any relief either in law or in equity. Cardinal principle. Tatkal, it has been, my lords have got it, page 28, my lord. My lord, will kindly see Tatkal. This has been obtained by him on 36/2025 at 3:30. He got appointment. And this case is of 2020, when he is issued a show cause, then he is coming and saying, yes, a false case, I have been arraigned. What had asked him, he should have declared this. And even if this representation would have reached us, we would have taken a call on it. Now, Lordship will kindly see our instruction. Lordship will kindly go through the instruction once. I don't want to waste my lord's time. But the brief facts I have stated, Millard. Millard, we have also said the response for petitioners, so-called notice still awaited under the heading brief facts of the case, my lord.
Yes, yes.
Now, Lordship will kindly see the GSR, which we are following, Lordship will kindly see page 10 of my Lord's. No, page 3. My Lord will kindly see page 10. The office memorandum starts.
Yes.
If my Lord kindly say GSR 57E, that is the second paragraph. 99 is in exercise of power conferred by clause A of section 22 of the Passport Act and in supersession of the notification of the Government of India in Ministry External Affairs dated so and so, the central government being of the opinion that it is necessary in the public interest to do so, hereby exempts citizens of India against whom proceedings in respect of an offence alleged to have been committed by them are pending before a criminal court of India, and who produce orders from the court concerned permitting them to depart from India from the operation of provisions F of subsection 2 of section 6 of the Act, subject to the following conditions. The passport be issued to every citizen. These are now, Lordship, he has not, then my Lord will kindly allow me to place page 11. My Lord will take a note of page 11, paragraph 3. And then, Lordship, paragraph 5, subparagraph 2, NOC from the court.
Yeah, that is required.
And Lordship will kindly see, so nothing. Here, Milord.
Yes.
Will kindly, if my Lord kindly allows me to place 10.3, Lordship will kindly. My Lord will be more convenient. My Lord will have to fetch for the book. 10.3. The passport authority, Lordship, 10.3. My Lord, 10 I have opened.
Yes.
My Lord. 10 subsection 3. The passport authority may impound or cause to be impounded or revoke a passport or travel document if the passport authority is satisfied that the holder of the passport or travel document is in wrongful possession thereof, if the passport or travel document was obtained by suppression of material information. In his show cause, which was never received by me, first paragraph, subparagraph, he's saying yes. Where lies my folly?
Yes.
Now, my Lord, he is coming to my Lord in a constitutional court where I can do everything under the sun, and when I am caught on the wrong footing, I'll show victim card. This has become the order of the day. I am facing everywhere. Any implementation of law for the welfare of the society where we are wanting to do clear suppression of cards. He would have, my Lord, we are not saying that we are, now he is coming with a judgment of the Honorable Supreme Court. Does it match the factual aspects of this particular case, Lordship? And even he is campaigning for a cause that he has given me that representation. He is unable to show how he has given me. Ask him to affirm an affidavit that he has sent it to me.
Yes. May I, my Lord, I hope.
Lordship, first of all, now my Lord will kindly come to his own pleadings. If my Lord kindly see the application where he has applied at page 28.
Yes.
It's under a Tatkal scheme type of application. Lordship has got it. Now my Lord will kindly see on the same page. Last but 10 lines. Keep your mobile silent just after that. My Lord has got it.
Yes.
Applicant applying under Tatkal scheme may please note that the application processing at Passport Seva Kendra may take approximately 2 hours due to additional verification required for processing such application. Therefore, Tatkal applicants are advised to plan the schedule accordingly. Now, so he has applied it under Tatkal. Now, Lordship will kindly come to page 30. Declaration by the applicant. Case 30, my lord.
Yes.
Declaration by the applicant, lordship has got it. I understand and I agree that I have applied under the Tatkal scheme and my application be put on hold in case of documentary insufficiency. In such a case, I agree to submit required number of documents at the latest. Now, lordship, this is very important. I also state that I do not belong to the ineligible category. I agree that if I am found to be belonging to ineligible categories at a later stage, my application may be processed as per the guidelines for the category. I agree to the decisions of GO, APO, RPO shall be considered final. So, Milord, when you apply for a Tatkal, you cannot come before the Honorable Writ Court and saying that if I have faulted in giving information, I have a right. Then lordship will kindly allow me to pay 2 weeks by the office. Previous PBR status, yes or no? It was to be given by them.
Yes.
So he has said police verification report status.
Where from
The
your
lordship, to be checked by the office.
where from your reading?
Malo, that same page 30.
Yes.
There is a column previous PBR status adverse. He has said yes.
Yes.
So when he has
Yes
said
or no?
yes or no, he has said yes.
No, let us not assume that I have said yes.
I am assuming how you have sent the representation first.
Yes.
And then how you are affirming that has reached me. First, let them come up before my lord that how they have given that to first. Now, lordship, so my lord, in my respectful submission, my lord will kindly see that there was a Tatkal scheme where we say that whatever you say, we take it as gospel truth, and if it is found that there is something wrong, we are well within our rights to cancel that. But giving you as a matter of abandoned caution, we have asked you to give us a show cause and explain as to why. The first that letter has not reached us till now. Even if that letter is for the sake of assumption taken, the first paragraph, sub-paragraph says that yes, I have been in. Now that case is of 2020. You could have disclosed that. The Tatkal scheme has come for the benefit of the public at large. If now public at large and now we will be held responsible. Why? If we don't give Tatkal, then people will come to my lord. If we give Tatkal, people will again come to my lord. Where is my salvation?
No, I am thinking who has given the certificate. Okay.
My lord, I as my lord's officer, my lord, we are looking.
Not under section 6, my lord, that is the case. Under section 6, a declaration is necessary.
No, that is not
And
my
section
case is
6
he has
says-
come with, he has suppressed material.
Yes, that is, my lord, the case is,
and
the
he is not
case of the
entitled to
state,
any relief.
state is that I have come with unclean hands and not entitled to equitable reliefs. But I am not on equitable reliefs. I am on constitutional rights and how it is being
No, but
interpreted.
the problem is that you have applied very good. You applied for the Tatkal.
I applied for the Tatkal,
You
my lord,
applied for the Tatkal.
and Tatkal,
But you
Tatkal,
not stated that you are having the case pending against you, and this is not a case registered against you within a month or 2 months before. It is the 2020 case, and under the Drugs and Cosmetic Act, and you have given the declaration that you are not ineligible for
Yes.
any categories. So, as per the Act, if it is a criminal case under the Act itself, seeks to bar, but as per the notification of 1993, exemption has been given. If a criminal case is pending, then you have to obtain a report from the no objection from the court, and if you got the no objection, then the authority will consider.
Lord,
That is the
your lordship will certainly reprimand me.
Huh?
Will certainly reprimand me for my conduct. Although I say that my knowledge, the petitioner's knowledge with respect to the pendency of this matter was fragmented. But as your lordship has said, my lord, I applied for Tatkal. Your lordship has said you should have said, rather than knowing the law too much by citing judgments, you petitioner may think that he is eligible because of the judgments of Supreme Court.
Correct.
But there is statutory requirement is there.
What?
Now, statutory requirement is to disclose.
Yes.
Now, my lord, that has not happened. But I am going with what your lordship is flowing, my lord. Now, they have, my lord, issued me a Tatkal passport
Correct.
with the caveat that it is subject to police verification.
Correct.
I have accepted that.
Correct.
After that, my lord, they give me a show cause notice.
Correct.
Today, it is told by the state that they have not received the show cause reply.
Yes.
But certainly, they have received the show cause reply along with my writ petition.
Show me the pendency.
No.
Show me the acknowledgement.
Acknowledgement. My lord, I have mentioned that I have served it to them.
No, you have not mentioned.
But,
My lord,
no, on instruction. That's why, my lord, my junior went. On instruction. That's why, my lord, my junior went. Now,
show the
now,
acknowledgement.
my lord will see. For example, my lord, not for example, just for the sake of argument, my lord will kindly appreciate that they receive my reply to the show cause in the form of this writ petition.
See,
They have come up with, my lord, the
Mr. Banerjee, I am giving the faith of this case before the passport authority. You have to appear before the passport
Yes.
authority. Passport authority will impound this. Correct.
Yes.
If you want the passport to be renewed, you have to go to the criminal court, obtain no objection, file before the authority, you will get nothing else.
And my lord, I am
The
supposed to
simplicity
do
of
this.
theory.
I am supposed to do this only because I have not shown proof of reply of the show cause.
Even proof, if you shown also, I admit you submitted the reply. Even though what the color will change of the case, because admittedly you obtain the passport on Tatkal.
Yes.
Admittedly on when you have
Subject to police verification, police verification has shown that it is
and
a case.
admittedly on that day there was a criminal case pending against you. Under 6(2) it is bar. Under section 6 subclause 2 it is bar. But the government has given the exemption by way of a notification of 1993.
Yes.
Under the 1993, if any persons having the criminal case intend to obtain the passport or renewal of the passport to obtain the order from the criminal court. Correct. If the criminal court granted a specific time, the passport will granted a specific time. If the criminal court granted no time, only given no objection, 1 year. There is a conflict. My judgment is conflict. So the Delhi High Court judgment is conflict. Supreme Court judgment is silent. Supreme Court
I have a
judgment is
pleading.
silent.
My lord, I have a pleading in
So what I say, instead of doing so, you go appear. If they passes any order, the authority will pass and will not say you lifetime you have been debarred. The authority will say it has been cancelled. You go and obtain the order from the criminal court. You obtain the order criminal court.
Absolutely.
You get it.
I bow down to what has fallen from your lordship. I only want to indicate that, my lord, in March 2026, petitioner had filed an application in the learned additional session judge for granting no objection. In renewal of the
Where from you reading?
petition,
Paragraph 11.
paragraph 11.
At page.
This is not addressed by the state in the report.
Okay.
My lord,
No, just a
moment
moment,
he speaks, my lord, I will come. My lord, it is better, my lord, he does not make any aspersions against the state because he is not well versed of what he is saying.
Kindly see, my lord, paragraph 11. For granting no objection in renewal of the aforesaid passport of your petitioner for the period of 10 years.
Correct.
I only say this, my lord, that I have done this. Whatever has fallen from your lordship, my lord, and of course, your lordship has indicated it has to be a time-bound thing. Otherwise, it cannot be till eternity.
Correct.
Lordship will pass that out.
Correct. You go, when you go and submit, go, file the reply, authority will take decision.
Within a week.
Take decision in
I will do that with you.
My lord, there are several orders passed by my lord. I buckle under that particular. But my lord, if they say that passport authority was wrong, you will not. You will suppress fact. You do not have. You have not even affirmed how you have served P5.
That's
As your lordship, please. Kindly, my lord, I will do it within a week. Let them also take a decision within a week. And we will, my lord, because this is old story for them now, my lord. This is old story for them.
Whatever.
Thank you. The petitioner has filed the.
My lord, kindly one humble submission. Lord, Mr. Mukhopadhyay has correctly pointed out. I have already given a reply. Now they have the reply. Let them decide within a week.
No, I will.
This writ petition.
You appear because what's it? Kindly see the so-called notice.
Yes, my lord. Yes.
You have to appear along with the passport. You appear And I am telling the what
Yes,
would be
yes.
the what would be the order of the passport or the
Yes.
passport of the passport will impound
Kindly, my lord,
with the
make everything
direction to
time bound.
obtain the report from the court.
Kindly make everything time bound. That would be the best gift.
But it is up to you how soon you will get the report from the no objection from the trial court.
Trial court, I have to go for the second time. If
Ah.
I get the grace from your lordship, then it's definitely within a very short period.
The petitioner has filed the present application challenging the SOCUS notice issued by the passport authority directing the petitioner to appear before the passport authority within 21 days along with the SOCUS notice and passport. Full stop. SOCUS notice बोला है ना dated 25th of September 2025 ऊपर में हाँ 2020 where is SOCUS notice? Where is SOCUS notice? 2025.
Yes, September 2025.
Until
September 2025, if I have actually not given it to them, I gave the reply on 6th of November 2025.
no, SOCUS notice is 2025.
Yes. So, my lord, it is not 2026. Now, the state passport authority, I'm sure will not.
And you have not surrendered and the passport authority has not taken any step.
No, because I came before your lordship.
You are the lucky enough.
No, my lord.
Yes.
You are the lucky enough.
Well, my lord, I'm just coming.
They have not taken any step against me, which means that they have received my reply. Let us not go into all these things, my lord. Whatever is coming from your lordship. The passport authority has been very graceful towards me. That is what I am appreciating their conduct.
The petitioner submit that the petitioner has obtained. Petitioner had a passport which was valid from 9th of December 2016 to 8th of December 2026. 9th December 2016 to 8th December 2026. Before the expiry of the earlier passport, the petitioner has applied for renewal of the passport on tatkal basis on 25th of June 2025. On the basis of the tatkal application, the passport authorities have issued the passport to the petitioner, which was valid from 1st of July 2025 to 30th June 2035. 2035. Full stop. The petitioner submit that after receipt of the SOCUS notice dated 25th of September 2025, the petitioner has submitted the detailed reply to the passport authorities along with the several judgments passed by different high courts as well as the Supreme Court. As the authorities have not withdrawn the SOCUS notice issued to the petitioner, accordingly the petitioner has filed a present writ application. The petitioner submits that ASGI submits that the petitioner has obtained the passport by way of tatkal application. In the said application, the petitioner has given the declaration that he do not belongs to the ineligible categories, and he has also agreed that if he found to be belonging to ineligible categories at later stage, his application may be processed as per the guidelines. He submits that after the issuance of the passport to the petitioner on tatkal basis, the passport authorities have received the police verification. Authority received police verification report, wherefrom it was found that a criminal case being Arambagh PS case number 235 of 2020 dated 26/6/2020 under section 27 capital A slash 28 capital A slash 22 within bracket 3 of the Drugs and Cosmetic Act is pending against the petitioner. Pending against the petitioner. He submit full stop. He submit that when the respondent authority, when the passport authorities have received the said report from the verification report from the police, the authorities found that the petitioner has obtained the Tatkal passport by suppressing the fact with regard to pendency of the criminal case against the petitioner. Thus, the notice under section 10 within bracket 3 of the Passport Act 1967 has been issued. Full stop. Learned counsel for the learned ASGI submits that though the petitioner has enclosed the alleged reply to the notice dated 25th of September 2025, but the annexure does not reflect that the same was acknowledged by the passport authority. He submits that he has submitted an instruction from the authorities wherefrom it reveals that the authority has denied with regard to receipt of the said alleged reply. He submits that the petitioner has obtained the passport. He has also referred the application filed by the petitioner for grant of Tatkal on 25th of June 2025, wherein also it is mentioned that
Page 30, last page 30. Declaration by the applicant.
Yes.
Last but 3 lines.
Learned ASGI referred the application filed by the petitioner for grant of passport on Tatkal basis and has referred the declaration of the applicant. The declaration reads as follows. Page 30, Eta Corridor. Okay. Consider the submission made by the counsel for the respective parties, peruse the materials on record. Admittedly, the petitioner has obtained the so-called.
I'm sorry to interject. May I request your lordship to kindly consider this judgment one, just one paragraph, Mahesh Agarwal, paragraph 21 and 22. Copy.
The petitioner has relied upon the judgment in the case of Mahesh Agarwal versus Union of India and others, reported in 2025 live law within bracket SC 1238. Which paragraph?
21 and 22. The lordship is completely up.
And submits that.
It's important. 22, Millard, is what my submission would be before your lordship.
Submit that a passport is a civil document that enables its holder to seek a visa and subject to other laws and orders to cross international border. Whether the person who is on bail or facing the trial may actually leave the country is a matter of the criminal court, which can grant or withhold the permission, impose conditions, insist on undertaking or refuse leave altogether. He submits that in the present case, there is no condition imposed by the criminal court for living in India, and as such the petitioner has applied for the passport. He further submits that before issuance of the present present passport, on the earlier several occasions, the petitioner has visited several foreign countries. And there was no objection from the criminal.
Right, that is my submission.
Criminal court. I have recorded your submission. Any further? No. Full stop. At the learned counsel for the respective parties, peruse the materials on record. Admittedly, the petitioner has obtained the passport on tatkal basis. The passport issued on tatkal basis only on the basis of the declaration given by the petitioner. Subject to verification, receipt of the verification by the police authority. In the present case, the petitioner has applied for the, in the present case, the petitioner in the tatkal application has given an undertaking, given a declaration as mentioned above. On the basis of the said declaration, the passport authority has issued the tatkal passport. But immediately the authorities and the passport authorities have issued the police verification report, wherein it found that the petitioner is facing trial before the criminal court. Thus, the authorities have issued the notice to the petitioner for appear before the passport authority along with the passport. Section 10, subsection 10 within bracket 3 of the 3 within bracket A provides that if the passport authority is satisfied that the holder of the passport or the travel document is in wrongful possession thereof, the authorities have the right to impound or revocation of the passport of the travel document. In the present case, it is the specific allegation that the petitioner has obtained the tatkal passport on tatkal application, giving the declaration that he did not belongs to ineligible categories, and is also given the declaration that at later stage his application may be processed for the guidelines for the said category, and he agree the decision of the Government of India APO of the RPO shall be considered final. In the present case, the authority, after issuance of the tatkal issuance of the passport to the petitioner, the authorities found that the petitioner has suppressed the fact that the criminal case is pending against the petitioner. Section 6 within bracket 2. Section 6 within bracket 2. Section 6 provide for refusal of passport or travel document. But the notification, as per the notification issued by the Government of India, dated Government of India being notification GSR 570 within bracket capital E, dated 28. What is the date of the GSR?
My lords, with page 10.
This is bracket GSR 570 within bracket capital E, dated 25th August 1993. Exempt the person who is having the criminal cases pending before the criminal court, subject to obtain order from the criminal court. But in the present case, the petitioner has not obtained any order from the criminal court. But in paragraph 11 of the present application, it is mentioned that the petitioner has filed an application.
10 and 11. 10 also.
10 and 11 of the application, the petitioner has mentioned that the petitioner has filed an application before the criminal court for grant of no objection for renewal of the passport of the petitioner for a period of 10 years. Considering the said averment made in the said application, this court find that the petitioner had the knowledge that the petitioner cannot obtain passport without the order from the criminal court, but has obtained the order from the passport from the authority on tatkal application tatkal application by suppressing defect. Accordingly, this court finds that there is no merit in the present writ application. The writ application is dismissed. Full stop. The petitioner is directed immediately to appear before the passport authority within a period of 1 week from date.
Yes.
And if the petitioner appear before the passport authority within a week from date, the passport authority shall take appropriate steps and pass appropriate order within a period of 2 weeks thereafter.
But upon granting a physical hearing, if that can go.
Appear.
Yes, I will appear, certainly. Upon granting a hearing.
By granting hearing to the petition in accordance with.
2 weeks, only this. Milord, I'm deeply obliged. And sorry, Milord, we overshot the time. I'm deeply obliged.
This I am keeping, then it will give it to you. Book. Yes.
Obliged.
Lordship, may I be permitted to mention one matter? Item number 4 and 5 was fixed at 3:45 PM in today's list. May it be fixed some other day.
So far as 4 and 5 is concerned, the matter is pending with the Honorable Supreme Court of India. Regarding the subsidy of matter, T scheme another framed by the T board. So, your Lordship can fix it. Now, division bench of our High Court held, is a government policy, court should not interfere.
No, that is already disposed of by the Supreme Court, I think. No.
No, pending.
No, my lord.
Ringtone matters, the matter is pending.
Okay. So,
may it be fixed some other day, my lord.
but if the Supreme Court, the matter is pending,
Today also,
which you are asking the benefit of the order that is pending with the Supreme Court. What the court
142 and 143, appeal side matter, your Lordship also admit please to adjourn the matter. Same matter.
When the next date is?
Matter is pending with the Supreme Court.
No, when the case is adjourned? 12 PM matter, 12 PM matter, 2 PM matter.
Very well.
Item number?
Item number 4 and 5.
4 and 5. Learned Counsel appearing for the respondent authority submit that the matter is pending before the Honorable Supreme Court. It is further submitted that the analogous matter was taken up for hearing by this court at today at 2 PM and this court has adjourned the matter till the month of October 2026. Let this matter be appear in the combined monthly list of October 2026.